draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, all. Welcome to the Appellate Division First Department. We have oral arguments for today, April 10. So please ask for the time that you need to get out the salient points of your arguments. Please understand that we have read your briefs. We are fully familiar with your arguments. People v. Renping G. 5, 2, and 5. People Care v. Contract Dispute Resolution Board. 626. Matter of Yuritsa, that matter is submitted. Morales v. St. Paul and St. Andrew. 625. Sandival v. 4 World Trade Center. Those are two matters. They will be called together. And whom do you represent? I'm sorry? And I'm sorry, how much time are you requesting? Yes? I thought you said you were Palladium. Yeah, I must have misheard. I thought you said you Palladium as well. 5-2, 5-2, 5-2, and Palladium, how much time were you requesting? I'm sorry. Palladium? Wait. Stand up. Wait, yeah, I thought you said you were Palladium. So, do you guys know each other? Oh. Okay, so who do you represent? Who is that? Okay. Well, we give you 4 minutes because I don't know who you are. People v. Christian Toro. 414. Chan v. the City of New York. 525. SC Property Development versus MW Capital. 525. People v. Delvon, Washington. Two matters to be called together. Both are submitted. Roosevelt Lee 38 versus Lee. That matter is submitted. Flowers v. District Council 37. I'm sorry, I know. Go ahead. Go ahead, Flowers. Five and 2 and 5. Wong. Oh, I'm sorry. 5254. Wong v. Wong. 626 and 2. Baton v. the City of New York. 626 and 3. Carter Bergen III versus Pamplona Capital. And who are you? And how much time are you requesting? I'm sorry. 6, 2, 5, and 5. Schoolman versus Alliance Energy. 423. People v. Dwayne T. Williams. 424. McMillan v. Outlook Safety. That matter is submitted. First case for argument, People v. Renping G. Whenever you're ready.
May it please the court, Grace Miller with King & Spalding in association with the Office of the Appellant Defender on behalf of the appellant. When the prosecution charged Mr. Guh with 11 counts of identity theft, the prosecution took on the burden of proving beyond a reasonable doubt that Mr. Guh knew the information on the cards belonged to another real person. Without evidence going to this critical element, the prosecution's argument rested on the assertion that if the information on the cards in fact was another person's, that Mr. Guh knew the information belonged to another person. This assertion fails where the prosecution did not provide evidence of the origin of the credit cards or
I thought the defendant stated that he had purchased these cards on the Chinese equivalent of Craigslist.
So there were two different cards involved in the matter. One was the 1829 card. There was no evidence of origin on that card. The statement you're referring to is in regards to the 3523 card. There was some evidence that Mr. Guh stated that he had purchased the card. However, he didn't directly state this to the court. The only evidence,
He didn't directly state this?
he didn't state it to the court. The only evidence of where the card came from was in a report that said that Mr. Guh bought the card. However, there was no evidence of the actual website presented at trial. There was nothing that showed.
So this was a jury trial. The investigator testified that this was a statement made to him. So I'm not really understanding how you're stating that he didn't make this statement to the court.
The investigator actually did not testify that Mr. Guh said he bought the card. The basis for saying that he bought the card was one word in the report. There was the evidence of the origin of the card was a Chinese website. Both of the witnesses testified as to the website that Mr. Guh attempted to load and show them, said that they couldn't actually read what the website said, which leaves open the possibility that the website misled Mr. Guh into what the card actually did.
So he goes onto this website, and what did he think he was purchasing?
Based on the evidence, it's equally plausible he thought that the card had fake account numbers or that the card functioned as a gift card or a rewards
Let me just
card.
ask you about that fake account numbers situation. How does your argument play with People v. Roberts out of the Court of Appeals, where they basically said that it's the numbers and the account, which is the identifying information, not necessarily names?
It aligns with what the court said in Roberts. The Court of Appeals in Roberts noted that identity theft does not apply to situations where a fictitious identity is created because the statute itself is meant to protect real people. Roberts focuses on the actus reus part of the statute. It doesn't extend to the mens rea of the statute. It says that if you use someone else's account information, that's enough for assuming identity. But the statute also requires that you assume someone else's identity knowingly.
Counsel, when you say that you didn't, I'm not sure that I appreciated your last argument as opposed to what he thought he was purchasing. If he thought he was purchasing something fake, then he walks into Barney's and tries to charge on it?
Right, that would not be identity theft. That would be fraud or some other type of crime. Even if his conduct...
That's not the point that I'm getting at. So you if you're purchasing something fake, you don't... He has an expectation that he's purchasing a fake credit card, and it has an expectation that he walks into Barney's and tenders it to pay $12,000 worth of pocketbooks that it's going to work?
You could. There's ATM skimmer cards that allow people to...
That wouldn't be fake then.
A skimmer card, it would be fake. It wouldn't be a real ATM card that you can use to draw money out of an ATM, even if it's not linked to a real account.
Were any of the names on the cards his?
Yeah, the name on the 3523 card was his name.
Was the encoded information his on that card?
No, it was someone else's, but there was proof of the question of how to encode a card at trial the witness testified that encoding a card requires specialized equipment, such as a card encoder or something that can print on a card. There was no evidence that Mr. Guh had this ability. Without showing...
The 3523 card, that also bore the name of another person, or another name rather, Ziyun Chen. That's not him, or is that his name as well?
That was the 1829 card, and in that instance, there was no proof that Xu Chen was a real person at all, which would align with Roberts, which says that identity theft does not attach to...
I understand your argument, but I'm reading Roberts, and I have it in front of me, and I don't see where the court specifically states that.
States which part?
The fact that in terms of aligning with, excuse me, in terms of identity theft and the knowledge that there's an actual individual in terms of establishing the mens rea.
Right, because the court didn't reach the question of mens rea. The two defendants that they address in Roberts actually had evidence going beyond what we see here. For instance, one of them was found with a piece of paper that had a full financial profile of the individuals whose identity they were stealing. That type of evidence isn't here. The only evidence that Mr. Gunn knew there was another, the only evidence that Mr. Gunn had other people's information was the account number encoded on the strip that was not visible to him. Based on that evidence, there is not a reasonable inference. However, in Roberts...
What would be the reasonable inference? So these cards he purchases on this, this site, he knows that they're not issued to him by a reputable bank or financial institution. At least one card has someone else's name. Another card is encoded with the information from someone else. So how would this not be identity theft?
Even if those facts tend to show that he wasn't entirely innocent in his conduct, those facts, none of those facts go to show that he knew it was another real person's information. It's equally as plausible that he was a low man on a criminal scheme and had no idea and was given these cards and told to go purchase something and went and bought the items and thought that he would get money, but had no idea how the cards worked at all. That would not constitute identity theft. There are other crimes.
He knew the cards weren't his, right?
There's no proof that he knew the cards weren't.
His name's not on it.
His
He
name
bought
was,
it off a Chinese website. What did he think he was buying? His own credit card?
his name was on the 35.
We have a credit card application or anything from Barney's, which is no longer in existence. Barney's issued him a credit card?
There was no evidence whatsoever about the application.
And you're saying that circumstantial evidence isn't sufficient for a jury to find, as it did, that he's guilty of identity theft?
Yes, Your
I
Honor.
mean, he didn't testify. He said, right? He didn't put in any evidence.
And let me just say that to follow up on that, Roberts, from what I remember in reading Roberts, also talks about a cumulative effect and cumulative evidence in terms of the individual's knowledge as to whether, as to the identity purported on the cards.
Yes. So one thing is that the record is not clear that he actually bought this, that he actually bought the credit card. The only evidence of this is testimony of this website that was in
Why does the
Chinese.
record have to be clear? Well, first of all, again, I'm back to the investigator and his purchasing on the website. So the record, you're stating that the record isn't clear. Why do we need any actually backstory in terms of where he received the cards if in fact we know that those cards did not belong to him?
Because there's an assumption going from assuming that because the cards didn't belong to him that he knew that. If you look at the cases that are cited.
I'm sorry, you don't know that the cards don't belong to you?
Yes, Your Honor.
One person that's in a unique position to know that.
Right, I know whether it belongs to me or not.
Not necessarily.
I know if I had a Barney's credit card, which I did, but I'm not understand. I really and truly do not understand your argument. You're saying that he could have been low man on a totem pole. You don't know where he received the cards. So you could also, therefore, there's a reasonable inference that he stole the cards, right?
And
I think that Roberts really does go on to say that when you present a card such as this that has information that's not your own, that is assuming that that person is committing identity theft. I don't understand how you're distinguishing Roberts from
Right,
from these
and
facts.
this is Roberts at, what page is this? 412, it looks like. But anyhow, you have time on rebuttal. Thank you. Yes.
John Cheever for the People. Good afternoon.
I just want to clarify, the two people who testified that he said to them that he went on this website. Am I correct in that?
So you're correct, Your Honor, that they testified as to him saying he went on the website, and they describe it as, I think, a Chinese Craigslist. But one thing I would clarify is the statement that the defendant makes that he bought the card is actually in an exhibit introduced by the defense at trial. And no witness testifies to that statement, but it's in this report that's admitted by the defense on cross.
What kind of report is it? Is it a...
It's a report on the theft made by the security guard. I believe it's Mr. Rivera
Okay.
after the fact. and it was submitted on cross.
But the people he spoke to who testified as to his statements say that he went on this website to get these cards.
Yes, that's right.
So there was testimony. I was unclear to me that, because I thought counsel said, no, it's not clear that he, but there was unrebutted testimony that that's what he said.
So I think what counsel's getting at is that the word bought, the verb bought, which is itself pretty incriminating because you don't buy credit cards, that word comes from a report. It does not, that was admitted by the defense at trial. It doesn't come from a witness who testified.
Can you just raise your microphone just a bit?
Yes. Is this better?
Was the arguments that defense is making now regarding legal sufficiency, was this preserved below?
No, no. The counsel was explicitly asked at the end of the people's case whether they had a motion to make, and they declined. So no.
They declined. Okay.
Your Honors, the jury had ample evidence to conclude that the defendant knowingly and intentionally committed each and every one of these crimes. The exact same pattern repeated 4 times. Defendant's conduct was systematic. He went to the same retail store. He made a small purchase and then a big one. Each time he used a forged Barney's credit card. The front of each had a name and an account, but someone else was always charged for it. And at the
One
end
of
of the
those cards did have his own name on it, though.
That's right, but he never had a Barney's account. And there was testimony to that at the trial. And sorry.
I'm sorry, the fact that he made a smaller purchase and then followed by a larger purchase, is that evidence that he was testing to see whether these were valid accounts?
Yes, exactly. That's exactly what it's evidence of.
And each time he bought the same thing, right? He went in, bought shoes, and then bought a big, and then after the shoe transaction went through, or at least on 2 occasions, he bought shoes first, and then when the shoes transactions went through, he went in and bought purses, the same purses.
That's correct, Your Honor. So the first, it's a lot of shoes. The first 3 dates, May 31st, June 6th, and June 17th, the first purchase is shoes. And then the second purchase is a bag, or on June 6th, 2 bags.
And then he purchased, at some point in time, he purchased cologne, didn't he?
Perfume.
Perfume.
Yes, that's right. On June 18th, that's the first purchase. And then it's followed by a much larger purchase of other beauty products. The problem with the defense argument on appeal, Your Honors, is that it permits the jury to have made 0 inferences at the trial, and it assigns the people the burden of proving every fact and disproving every, in the defendant's own words, outlandish possibility, rather than the burden of proving the elements beyond a reasonable doubt, which we did.
Well, do you agree with your friend that Roberts stands for a different proposition?
No. The way my reading of Roberts,
Go ahead.
my reading of Roberts and the section of Roberts that we're talking about specifically, Your Honor, is that while it is not possible for a fake person to be the victim of identity theft, and I think that that section of the case is referring to the name Craig E. Jonathan, which I think is in the Roberts section of Roberts. So that person is not the victim of identity theft, but there's a real victim's account number on the back of that card, and that was given in conjunction with that name with that card, and that person is the victim of identity theft. And so that what Roberts is doing is saying the use of somebody else's information is a sufficient actus reus.
So as long as you have the credit card that belongs to someone else and you use it, you're not just committing fraud, but you're also committing ID theft.
Well, the account number is what is the identifying factor.
Correct. Correct.
In other words, you don't even have to have the credit card as long as you use the credit card numbers.
Absolutely. That's right.
Thank you.
Thank you.
Respondent's position that the defendant didn't have to know and only had to actually use the account number is the fatal flaw in the prosecution's theory and respondent's argument.
I don't know how you can say that in light of Roberts, which says exactly the opposite.
Not necessarily, and the jury was instructed in this trial according to the CJI, which explicitly requires that the defendant knew that they were assuming the identity of another person. That is a separate piece of
But
the,
isn't there enough circumstantial evidence here from which a jury could make that finding? He's using cards that are not in his name. He admits that he got them on a website. The way that he buys, what he buys, how he buys it. You don't need him standing up and swearing, yes, I knew. There's plenty of circumstantial evidence from which a jury could make that finding.
most of that circumstantial evidence, even if true, even if accepted, goes to show that there may not have, that the conduct wasn't entirely innocent. But identity
I
theft
don't
has a
agree. I mean, and clearly the jury didn't agree with that. The jury found that that circumstantial evidence was sufficient.
And that's the point. That's the bottom line, is how the jury viewed the evidence.
the jury, the way that the jury viewed the evidence wasn't looking at the specific identity theft mens rea. It was assuming guilt, a general guilt, to satisfy a statute that requires something above what grand larceny, what fraud, what other crimes require. We're not, like, even if his conduct wasn't entirely innocent, there was not a reasonable inference that the heightened mens rea requirement of identity theft, that you know that it's an actual person, was met. All of the cases cited in any of the briefing show more evidence that someone knew it was a real person.
So under your theory, how would the people have been able to prove their case? How would you be able to prove a case such as this?
If there was some evidence that the defendant even had the ability to re-encode the card, the specialized equipment they say is necessary to re-encode was something that wasn't
The
there.
defendant has to re-encode it himself?
No, but just the ability or showing that he had access to actually put
That
the
ability is from buying it from Craigslist.
That ability is from not the actual Barney's or the financial institution, not actually rendering the card to him, issuing the card to him.
But whether Barney's gave it to him or not does not show that that even if the card was fake, that he didn't think that it was a fake account or that he wasn't given the card under false
So let me just say,
pretenses.
so your theory is that it would have been a fake account, just not necessarily linked to a person. It was just numbers, and hit or miss, he was going to try it to see if these random numbers were actual, not an actual account, but just random numbers put together that would allow him to purchase things.
Yes, that inference is equally as plausible as other inferences. Yet based on the evidence, it is. There was
But
nothing.
wasn't there someone linked to those account numbers that he used?
In fact, there was,
was a
but there
person.
was no evidence of how he got that person's information. There was no evidence that he had the ability or access to get it or had the ability to put that information on the credit cards. None of that evidence is actually in the record. It's only that it in fact happened. And if you just look at in fact then and assume mens rea from that, then it's not requiring
In
proof
fact,
of
it's
the
almost a
independent
totality of the circumstances. You look at everything he did. You looked at him going on the website, purchasing these credit cards. None of them in his name. Then he goes into Barney's. He does small test purchases, followed by bigger purchases. He comes back and he does it repeatedly. It's clear.
And again, Roberts talks about the cumulative evidence, and that's what we're looking at. I think that's what you have to look at. But thank you both. Oh, you're pro bono? Oh, thank you for your service. We appreciate it. People Care versus Contract Dispute Resolution Board.
Good afternoon. May it please the court, Karen Klein on behalf of petitioner appellant People Care. This case concerns funds that People Care received for the years 2003 and 2004 in connection with a state program to benefit home health aides. The sole requirement
Do we have prior cases that address this issue?
that addressed the funds that were received, but the prior cases relating to People Care addressed whether HRA had the authority to audit and recoup funds generally. It did not address the merits of their demand for audit and recoupment, which is what's at issue here. So the cases previously went through the system on the issue of whether or not HRA could audit and recoup. This court, in a split decision, held that they could not. The Court of Appeal reversed, and then we went through the administrative process before the CDRB on the merits of the demand for recoupment.
Which explains why we're talking about 2003 and 2004, right?
Yes, Your Honor. So People Care ultimately spend the funds that they received for the statutory purpose, meaning the recruitment and retention of healthcare workers, after 2004, but prior to the time that
So
People Care was.
just to like maybe try to wrap, your position is that the 2008 audit was too late, right?
So no, Your Honor, the 2008 audit wasn't too late. However, the notice provided in connection with the 2008 audit that HICRA funds had to be spent in the year received, or alternatively, there had to be a pre-disclosed plan and process to spend those funds came too late. It came after People Care had actually spent those funds. And so again, People Care acted as a pass-through. We were a pass-through entity. We didn't profit or benefit from those funds. They were delegated by the state to People Care so that People Care would spend it on their recruitment and retention of workers. We did that after 2004, but before 2008. In 2008, there was an audit done, and HRA said, we demand back the $7 million in HICRA funds we provided to People Care in 2003 and 2004. It was only in 2009 when we disputed that HRA disclosed for the first time that there was a requirement that funds be spent in the year received, or else there had to be a plan and process disclosed for the expenditure of those funds. People Care.
Why couldn't HRA seek recoupment of those funds?
Well, People Care no longer had those funds. They'd properly spent them in accordance with the requirements as People Care knew them at the time. So People Care received the funds in around 2003, 2004, and it wasn't until 2008, 2009 that they were told that they had to be spent in the year received. And so,
Did you assert that before the board? I thought what
We did.
Did you?
We did.
I didn't see in the record that you actually stated that you had spent the funds.
We did, Your Honor. We spent the funds before 2008, and that's what makes this case distinguishable from the New York healthcare case. The New York healthcare case was a case that this court
I thought
considered.
it stated that People Care is fully committed to and intends to expend the funds received consistent with the stated statutory purpose.
People Care was required to certify that that was the case upon receipt of the funds, and it did. However, People Care, in fact, did expend the funds prior to 2008. That's in our petition, Your Honor. We say that throughout our petition in the court below and before the CDRB. However, in the New York healthcare case, which is the case that the court below and the CDRB panel determined was dispositive, the HICRA funds had been frozen by HRA and never spent. So HRA in the New York healthcare case told New York healthcare in 2004, there's a dispute. It wasn't relating to the temporal issue, but there was another dispute. Don't spend these funds, keep them frozen. The provider in that case froze the funds, didn't spend them, and by the time the audit happened years later, they remained unspent. And so
So you can see that HRA could recoup Medicare funds that were not expended within the year.
So they are allowed to recoup Medicare funds that are not expended pursuant to the terms of the contract. The contract does not have temporal limitations. In fact, the other Medicare funds that are distributed to People Care were distributed on a weekly basis, and based on weekly billings, we were required to then submit, kind of reconcile what was received. So it's not an
Whatever it may be,
annual.
You concede then that Medicare funds had to be spent within a certain period.
Or return to HRA.
The ordinary Medicare funds that were received pursuant to the contract, that's correct.
Right.
So isn't this a subset of isn't the monies that we're talking about here, isn't that a subset of Medicare funds?
Well, the Court of Appeals has already held that they are Medicare funds under the contract.
Why
However,
wouldn't the same
Medicare
temporal
funds under the
requirements
contract.
also- why wouldn't the same temporal requirements apply then, if it's a subset?
But it already does. I mean, HRA has already conceded that it doesn't. HRA has already said there's an annual requirement, and that requirement has an exception. That's the plan and process exception.
So-
Right? Neither of those apply to other Medicare funds. They've already conceded that it's treated differently in that sense. And in fact,
Can I interrupt
Your
you for
Honor.
a second and ask you, when you did your 2008 appeal, did you appeal on the ground that you already spent the money?
so they did not. Yes,
I just want to ask,
Well, that
that's
was
a
the
pretty
question
straight
that I
up,
asked you.
yes or no?
yes,
Did
Your
you
Honor.
appeal?
Yes, Your Honor.
No, you didn't. I'm looking at it right now.
the-
All you said is they couldn't. They weren't allowed to. But you didn't say, there was nothing. You put nothing in 2008 that actually said that you spent the money between 2004 and 2008.
Right, that's what the record that I'm looking at, that's what it said. And you just said a little while ago that you had spent the funds and you made this clear to the board that you had spent the funds.
In 2008, you made it clear to the
In
board?
2008, our objection initially related to, there were a number of factors. Number one was the authority.
I just
Number
want to
two was
ask
the
you, because
temporal
we're talking
limitation.
about the 2008 audit. Did you say at that time, we have spent the money?
In 2008, in our initial objection, objected to the temporal issue. However,
Again, I'm going to ask you again until you answer
I
it.
believe we did, Your Honor. I believe we did.
I don't think you did. If you did, show me where, because I looked at that record and I don't think you did.
And I'm looking at it now again, and I don't see it. I see what I read in that, you know, it's your intent to do so as per the provisions, but I don't see any statement that you did. But you can take a look and point us to it on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the New York City Human Resources Administration. 3 years ago, this court had this exact same case, considered these issues.
Well, that was my point. I do not understand why we are not bound by the prior cases, which I thought had been dealt with by us as well as then by the Court of Appeals.
I think you are bound by the prior cases, Your Honor. The Court of Appeals decision in 2021 and then this court's decision in City of New York in 2022 made clear that the methodology that HRA chose to exercise that authority that the Court of Appeals said we had was rational and consistent with the parties' contract. In that case, that New York healthcare case, they raised the same arguments that the petitioners are raising here now about, you know, what these HICRA funds mean.
So is there any difference between those contracts and or the methodology imposed and used in this case?
No, the contracts are identical. This court said in the 2022 decision that New York Healthcare's contract was identical to the contract in matter of people care, and the method of auditing and recoupment that HRA used for New York Healthcare is the exact same that it used for matter of people care. This
What
is
about this? Oh,
Go ahead.
what about this issue about the money being spent or it wasn't spent? What's your take on that?
ultimately whether it was spent or not spent is entirely irrelevant, because the point is that it wasn't spent on expenses that were incurred in the fiscal year for which the money was allocated. And so, under the contract and HRA's recoupment process that DOH approved, they were required to return any
And the
money.
contract is clear as to that the money must be spent in that fiscal year?
So the contract does not literally say that you have to spend the money in the fiscal year for which it was allocated. What the contract says, is page 290 to 291 of the record, is that HRA may recoup unspent funds when there is a difference between the amount that People Care is paying its employees and the amount that HRA provides to it.
Wouldn't it be better if it said per year, annually?
Certainly, it might be better if it said per year annually, but the point is that the contract gave HRA the authority to recoup these excess overpayments, and then HRA used its discretion under the contract in conjunction with DOH's authority that it
So on
provided
that
to
point,
it.
doesn't the contract also say that you could recoup if these particular funds were misused?
Absolutely. The contract says you can recoup if funds are misused. You
Isn't it
can,
limited to that? Does it give any other scenario where these funds could be recouped?
yes, yes. So page 290 to 291, it specifically says that if there is a circumstance where HRA provides money to People Care in excess of the amount that it's paying to its employees, that HRA can recoup that amount. And so the HRA rationally chose to measure that question. When is there an overpayment? When is there money that's unspent? They rationally chose to do that on an annual basis because DOH's methodology that it imposed on HRA was this automated.
They're not disputing the fact that you have the right to recoup, right?
So that's correct. They are not disputing that we have a right to recoup. I would say they're disputing the fact that we have a right to recoup on an annual basis.
Right.
Or
And then
on funds already spent?
What's
Because
that?
they said that they spent them at some point.
Yes, but again, to be clear, whether they spent them or not is irrelevant because money is fungible. If you receive an overpayment that you're not entitled to, you can't avoid having to pay that back by saying, oops, we spent it. If you don't have that dollar, you have another dollar. That's the way money works.
So it's your argument that regardless of whether in 2021, they said we already spent the money. That really is irrelevant because as of the 2008 audit, they owed the money because they hadn't spent it in 2003 through.
That's right, Your Honor. It's irrelevant. And that's, this court in that 2022 decision in City of New York emphasized that it was rational for HRA to audit and recoup money that was left unspent at the end of each fiscal year. It didn't make any statement about whether or not at some point later down the road, years later, People Care spent that overpayment that they received that they were not entitled to.
Now, your friend made an argument, I believe, that these monies are different, that this is some type of a subsection or a subcontext.
Well, for practical purposes here, they're not different because the Court of Appeals held in 2021 that they are not different. They are Medicaid funds, and they are treated just like any other Medicaid funds that People Care receives. People Care has been receiving Medicaid funds since the 1990s. They have always been subject to HRA's annual audit and recoupment methodology, and that's the process that HRA has applied for decades with the Department of Health's explicit blessing. As Justice Richter noted in her dissenting opinion in that 2019 decision, that DOH's determination there is entitled to deference here.
Thank you.
Thank you, Your Honors.
Thank you, Your Honors. Just to begin, I'd like to point the court to page 57 of the record. We did notify, just so it's clear, this was a letter in which People Care did in fact notify HRA that the funds had been expended in connection with an employee stock plan that became effective on January 1, 2007. So we did in fact notify.
Would you agree that the funds needed to be spent on their purpose? Was that consistent with the purpose?
It was, Your Honor, and HRA has never actually undertaken to audit whether they were spent for the proper purpose or not, and we welcome such an audit. They've only undertaken to say they weren't spent at the proper time, and we didn't know that that was the proper time then.
Right. I guess what I was asking you was not whether you notified them, is that whether you raised that issue in in 2008, whether you said in 2008, and by the way, we spent it, because that's what I didn't see.
Yes, Your Honor, this was a letter from 2000.
Right, it was a letter, but there's an appeal, right? You're doing an Article 78 on the CCRB or the Contract Resolution Board appeal.
Yes,
right?
so this was a part of the appeal.
Of the appeal process?
Of the appeal process, yes, Your Honor.
See that argument?
Yes, Your Honor. There were a series of letters going back and forth
right.
over a series of many years.
Got it.
This was one of the early letters that we sent in 2008 or 2009.
Okay.
But again, does it matter if
Right.
the funds were not expended during that year?
It does, Your Honor, and it does. And I'll just say in terms of the whole money is fungible point, right? So if you look at page 358 of the record, you'll see that these HICRA funds are in fact treated differently in that they have zero profit component to them, meaning none of that money went to People Care. It's not fungible money whereby People Care got to keep it and spend it how we wanted. People Care was a pass-through here and provided this money directly to the employees through the stock plan. We didn't keep this money. So it's extraordinarily distinguishable. And I would just say, thank you.
Morales, the St. Paul and St. Andrew. Whenever you're ready.
Okay. Good afternoon, Your Honors. May it please the Court. My name is Jennifer Adler, and I'm representing defendants' appellates. So, as you probably know, this case is about the interpretation of a video.
Well, on that point, in the video, I mean, there are two separate points, I guess, because the video shows that a ladder does move at one point, no fall, and then subsequent to that, either it moved or it didn't move, then there was a fall. Why isn't it enough to say that it was an unsecured ladder?
Because when someone purposely, fraudulently feigns an accident, how can you put that burden on the owner of a building? I mean,
Because if the ladder is unsecured, and our case law says, secured
I
ladders, especially like these A-frame ladders that are lean-in and things like that. They need to be secured.
But, and this is one of those cases where you can visibly see this man take 3 calculated steps up the ladder, very slow, and then he leans over and falls. He grabs the green wall.
So you're saying that this is one of those few cases that raises an issue of sole proximate cause. He's
At
the
the
sole
very
proximate
least,
cause of his own act, right?
I mean,
And if
even
people watch that video and could see that, or could find that that may be a good interpretation, at a minimum, it goes to a jury.
exactly.
And
At
that's
the
your
very,
argument, even if it's assuming, for purposes of my question, that it is clear that while he's ascending the ladder, that the ladder moved.
yes. Yes, because, I mean, you know, this isn't about whether a ladder is secured, unsecured. If someone is,
Well, that's what he's making it about.
well, I understand, but then at that point, we have 2 different views. You know, we have the view that he fell off the ladder because it was unsecured, or the view that he,
I mean, if we didn't have such a video, in a case where someone alleges that the ladder was unsecure and then they fell off, we're like, oh, unsecured ladder, label law violation. The problem here maybe is the fact that there's a video.
I mean, that is, I mean, isn't that part of what we, at least send it to a jury?
Right,
At the
because
very
we
least.
cannot state as a matter of law whether it moved or it didn't move, or whether he
Exactly.
jumped or he didn't jump.
I mean, and I think that Judge Hagler's own, colloquy during his arguments really make that clear, that this is something that nobody really could tell. And, I mean, well, we believe it's feigned, but at the very least, a jury should make a determination as to whether it is feigned.
Thank you.
Welcome.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. This video just raises no issue of fact for 2 reasons. First of all,
Have you seen the video?
I've seen the video,
How
and
many times did you watch? I watched the video at least 12 times.
I literally spent 4 hours on this video.
Oh,
And
well,
befo-
you're way better than me, but I had
No.
other cases to deal with. I'm not sure, speaking for myself, I don't know how you can say definitively that the ladder moved or it didn't move, or he jumped or he didn't jump. As a matter of law, can we say as a matter of law, it moved, causing him to fall?
I do, and here's why. Because 99% of the ladder is obscured behind a green wood panel. So, okay. We have plaintiff's testimony that's unrefuted, no witness. The video is
Except the video, except for the video, which does refute his testimony.
And here's why.
You and I might disagree. That's the whole point of sending it to a jury.
But here's why I disagree respectfully with you, is because we don't know in that half second before he falls what happened to the bottom of the ladder. It's obscured behind a green panel.
Yeah,
Did it
and I'm
shift or
going to ask
move?
the same question
Right.
that I asked your adversary, right? Because again, I would agree with you. In labor law cases, we do say an unsecured ladder that person falls off of, even if they lost their footing, maybe that's comparative, whatever the case may be, right? But in this case, we have this video, and are we the ones that are really supposed to be interpreting this video, or where it is so it can go either way, right? Let a jury decide that.
Because this ladder, it's undisputed that it was unsecured, and you see that it moves not
Also,
just.
the fact that the ladder's, let's assume that, for purposes of this question, let's assume that yes, the ladder is unsecured. That doesn't mean that someone can feign a fall from an unsecured ladder.
Right, it doesn't mean that he didn't, because it's unsecured, it doesn't mean that he didn't jump, as, which is their argument.
Yes, but the plaintiff testified that before he fell, the ladder shifted and moved, and that is undisputed, included by the video. The video doesn't dispute
Well, see,
that.
that's again, we're back to the video. And I understand, I agree with you in that it is obscured because of that panel or whatever. We don't know what happened at the bottom of the ladder. We don't know what was going on there. But in looking at it, you look at his body language, right? And so you look at the movement of his body, and again, I don't know how you can say as a matter of law that the ladder moved.
Let me ask you this. If I look at the video, and to me, who was watching the video, it looks 100% like he jumped off the ladder. Is that, and that's what I see from that video. Not that he fell, that he jumped. So, assuming that if that's how I interpret the video, does not that raise an issue of fact as to whether he is the sole proximate cause of his accident?
No, for two reasons. Because if you look at the video at 38:08,
I'm telling you what I see.
Right.
You can tell me
But
that
it
you see
shifted.
something different. That's entirely proper. But that, to me, says it's an issue of fact.
well, he can't be the sole proximate cause, as we know under Blake and his progeny, because there was a statutory violation. So he can't be
Yeah,
the sole
okay, so
proximate cause.
it's a feigned accident, which is a complete defense.
But if you look at the video, I would ask you to actually look at the video before.
Oh, we have all looked
We've
at
all
this
looked
video
at it.
many, many
Not to
times.
isolate the moment of injury, to look at the video from the beginning, and here's why. You have a ladder that you could see the workers that are going up the ladder with nothing. It is
Counsel, I
completely
understand
unsecured.
your view of the video, but assume that my view is not your view. If my view is not your view, having seen the same video, does not that raise an issue of fact as to whether or not this is a feigned accident?
I would say it would if you could see the ladder. You can't see the ladder, so you have.
So maybe he jumped because the ladder moved, and we don't know because we can't see it. Is that your?
Well, but if he jumped because the ladder moved, it's a statutory violation because the ladder moved.
He testified to that?
No.
No, he testified that. No, he didn't testify that he jumped off the ladder.
No, he's testified that the ladder moved, causing him
And
to
him
fall.
to fall,
But
correct.
there is a reasonable view of the video that he jumped.
If he fell, if he leaned and fell, which is what my adversary is saying, and it was as a result of the ladder shifting or moving for no apparent reason,
I
which
don't
is
know that that's what they're saying.
Well,
I
then, no,
think they're
that's
saying
what they're
that it's
saying.
feigned and he jumped.
they're saying that he lost his balance, and they argued this in opposition below. It's all over the record that he lost his balance, and then the ladder moved after he fell. That is their claim, 100%. And so this video.
I read them to say initially we thought for sure this was a feigned accident. That's what
No,
what the appellate brief says.
I'm sorry,
I
Your
don't know
Honor,
if
to
that's-
actually ask you to look at the record. It's actually not what happened. They opposed and cross-moved, not on that ground.
Well, I
Then-
mean, again, I don't know that it really matters that much where you're, again, asking us to find as a matter of law that the ladder shifted, causing him to fall.
I'm asking you to find that because plaintiff's testimony is not disputed by the video. I guess I don't have any time to get to the specious fraud allegation, so maybe she'll cover
Thank
that in
you.
reply. I would ask if I don't have an opportunity to reply to just look at the record, please. Thank you.
Thank you.
The court has no further questions.
No, but I mean, we've already held that we're not doing these fraud counterclaims in the context of a.
I understand that.
Right?
If the
So,
court would like me to
right.
address, I just.
No, but I just want to make it clear, we've already held that, and you haven't said anything that would lead us to reverse ourselves
Well,
anytime soon, right?
Well, I would like to make one statement on that. Everybody proceeds in litigation on a good faith basis, right? So you have a good faith basis that the complaint is true. As a court, you have to accept the arguments in the complaint is true. And we have no choice as defendants but to deny the claims and proceed and defend.
But you also have a remedy in the event that there is the kind of conduct that you think, that you are saying without any proof, with zero proof, happened. So you have a remedy. It's not in fraud. I think we've said that, and it's clear.
I will rest on my brief.
Thank you. Thank you both. Sandival v. Fort World Trade Center. I don't know who he represents. Palladium, it says. Whenever you're ready.
Good afternoon. May it please the court. Vincent Chirico for the plaintiff appellant on both appeals. And I'd like to submit up front that there's one issue that's wrapped around both of these appeals, and that issue is very simple. Did defendants sustain their prima facie burden of showing an absence of a triable issue of fact? And we submit that they did not, and that irrespective of whether the plaintiff, the appellant, submitted any papers in opposition to their summary judgment motion on the 202 claim, that they still had the burden to sustain their prima facie case, and they did not do so. And for that reason, we believe that there should be a reversal. We think that the lower court's original decision was absolutely right with respect to 202, although maybe for the wrong reasons. And on re-argument, the sole basis for granting re-argument and for dismissing the 202 claim was that plaintiff did not submit any papers in opposition and therefore abandoned the issue. And
Counsel, where have we ever held that a window washer, interior window washer, would be covered by labor law?
that would be the Wong case.
Really?
Yes.
Because I read that while I was watching the video on the prior case, and I thought that specifically we stated that it doesn't fall under the labor law. That case dealt with an exterior window washer.
And that's exactly what we have here, Your Honor. We had an exterior window washing on the roof of 4 World Trade Center.
Right, and in that Wong, I guess is how we're pronouncing it, case, it specifically says that Labor Law 241-6 does not apply to routine exterior window washing. And then we'll, going back to Nagel from the Court of Appeals in 2002, when we're talking about window washing and whether or not it falls within the labor law, we're looking at construction, demolition, excavation work. Do we have that here in this case?
Well, what we have is a non-routine window washing situation.
Right, but you can say non-routine, but that falls within a very specific area. Do we have that here?
We do.
How?
There's a contract on record page 771, 773, and 774, where you have all of the routine aspects of the agreement that are crossed out in that contract. And there's a proposed amendment that envisions an annual cleaning, but that was never agreed to. So you have we have Silverstein Properties who contracts with ABM to come and do window washing on call. When we call, you will come. Then ABM subcontracts that to Palladium. So what we have is an on-call situation, and therefore, by definition, not routine.
I'm not understanding again, this is 241 subsection 6 does not apply to routine exterior window washing. And your argument is that this was not routine because there was a contract in place?
No, because the agreement in place said we will call you when we need you. That
But
makes
that's
it
not what we
non-routine.
need here. Do we not need some kind of construction, excavation, demolition, or you're saying that that's
We
not?
do not. On the 202, we do not. It's purely for
Well, so you're-
exterior
No.
window
No,
washing.
you're reading routine as meaning every month or every couple of months, as opposed to what the work is actually being done. I don't believe that that's what any of these cases, when they say routine, they're not talking about, you have to come in every month and wash the windows. They're talking about routine in terms of the actual work being done.
Right, as opposed to window washing in connection with construction.
Right.
Well, that's what 202 says on its face.
So let's go back. Did you argue in opposition to the motion?
In the court below?
Yeah.
We did not.
So you've abandoned it.
Well,
That's.
I would agree with you, Your Honor, had the defendants established a prima facie burden of a lack
It doesn't matter.
of negligence.
You didn't raise it, so it's abandoned.
Well, not according to the Liberty Taxi case, which we cite in our briefs, that indicates even where the party against whom's judgment is sought failed to submit papers in opposition to the motion at all, the defendants still have the prima facie burden to sustain the absence of any triable issues of fact. That's whether it's at the trial court, even if the non-moving party doesn't appeal. This court has the power to search the record and to indicate their tribal issues of fact.
You have
That's all
time on
we're
me.
asking.
You have time on rebuttal.
Thank you, Your Honor.
May it please the court. I represent Respondent's 4 World Trade Center in this case. As you correctly noted, 241-6 does not apply to routine exterior window washing. This building was not under construction, hasn't been in construction for years and years. So 241-6 doesn't apply. 202 was abandoned.
Well, what about your friend's argument in terms of, since you didn't make out a prima facie, they can still come back with, excuse me, they need not address
We
it?
did thoroughly argue it, and we also discussed that there were no applicable industrial codes that could possibly apply, even though we were sort of arguing against ourselves, since they didn't interpose any potential industrial codes that could apply. So we were kind of arguing in the wind there, but nonetheless, we still made the argument that no industrial codes could apply to this. Certainly not 17D as in from the walk case, because it wasn't a passageway. It was
He was carrying, in the walk case, I think he was carrying water or something of that nature. In the walk case, I think he was carrying water to the.
right and slipped on a passageway. In this case,
Right.
He fell on a platform that was connected to the scaffold rigging itself, which was.
Well, he fell on a metal grate, didn't he, in this case?
Yes.
Yeah, which he thought may have been wet because of the morning dew.
Morning dew, and of course, 2 minutes before the accident, he walks right by it and doesn't see.
So that essentially negates the constructive notice for the 200, labor law 200 and common
Right,
law
and that was
negligence.
that's
Yeah,
the
okay,
reasoning.
That was
for
the
the lower
200,
court.
right.
Thank you.
Sure.
Are you Palladium?
Yes, I am, Your Honor.
Are you sure?
I'm positive. I was always positive. May it please the court, my name is Maurizio Saviordo. I represent the second, third-party defendant, Palladium, the employer in this case. I think the court's already articulated the reasons why the decision below should be affirmed. The defendants have established a prima facie case for summary judgment. It was argued that plaintiffs did not allege an appropriate applicable industrial code violation, which is a predicate to liability under the statutes he's suing for. That's a prima facie argument entitling us to summary judgment.
Under 202 also, even if we considered it, but
Correct.
but the plaintiff didn't argue against anything you said.
He didn't.
So
And
as
then-
we assume that that's a
That's
prima
what-
facie case,
Yes.
right?
And even if you considered the belated arguments, they allege violations of Article 23, which the court has already recognized do not apply to window washing situations. If there's no further questions for the court, I'll rest on our brief.
Thank you.
What about ABM?
ABM, AKA Palladium. Are you ABM or you're going to?
I am ABM, Your Honor.
Oh, excellent.
Good afternoon, Your Honors. My name is Christopher Moore for ABM. In this case, this wasn't construction. There is no excavation, no tools falling, no floor collapsing. It's routine window washing. The plaintiff doesn't know what he slipped on. He speculated that maybe he slipped on morning dew. Maybe he slipped on the bucket of water that his partner was carrying.
Well, he denied that, right? He denied he slipped on his own water.
I mean, he can deny it, but
Right.
Anything's never
possible.
saw the water. I'm sorry, Your Honor, what did you say?
Anything's possible because he didn't see it.
Absolutely, absolutely. So,
Thank you.
thank you, Your Honor.
If anything is possible, then they should be a tribal issue of fact. Now, industrial code.
Anything's possible other than the fact that 241 subsection 6 does not apply to routine window washing. And anything is possible except that there's no constructive notice or notice of the moisture on the grill, right?
Well, 2 points on that, Your Honor. First of all, industrial code
And
20.
you didn't put in any opposition.
Well, yeah, but I've argued that already with regard to their burden and our burden, even if we don't put in any papers. But 23(1.5)(b)(13), the description of the definition of work here says, all works in the type performed in construction, erection, alteration, repair, maintenance, including
Maintenance of the construction.
including, by way of illustration but not limitation, cleaning of exterior surfaces, including windows. And we know
During construction, in connection with construction. You cannot point to a single case that has nothing to do with construction.
well, we have the WOW case. right? And the Wild case permitted an amendment to allege the 1.7D that we're alleging in this case. And if you have a window washer who's going up the stairs and slips on the stairs, and you have a window washer who's up on the roof and he spills because there's no electrical outlet, and this is where the
So your
absence
argument is basically just as to 202. You're not really talking about 241.6.
Oh, no, we're arguing both.
Well, 241.6 in WOC says something different than what you're arguing now, but I just want to be clear, when you're talking about you don't need the construction part of it, you're talking about 202?
241.6 should be liberally applied to establish its intended purpose. And here you have 1.5C3 and you have 1.7D. And on the 1.5C3, there's a notice element to that. And again, it falls right into our main argument that at the first instance, defendants should have shown an absence of a triable issue of fact. Here, there's no question. The outlet at issue was not functioning, and Silverstein admits we never bothered inspecting or checking for this stuff. We only answered complaints. That's not their duty.
Thank you very much.
Thank you. I just want to take a moment. I
No,
saw
that,
Justice Mazzarelli here before, and I just wanted to say on behalf of the bar, she's welcome at any time.
She left. Where'd she
I
go?
know she did the other case, they left. I was so surprised when she came. Oh, nobody wants rebuttal? Nobody wants rebuttal?
You don't have to take it.
No one wants rebuttal.
Just say one thing.
Thank you.
Yeah, okay.
Bye. That was a statement, not a question. People v. Christian Toro. Killing me. Yes, you may proceed.
Good afternoon, Your Honors. My name is Thomas Palumbo of the Legal Aid Society, here today on behalf of Mr. Christian Toro. Now, Mr. Toro should be granted a downward departure.
Why?
Well, the guidelines of the RAI suggest that there are several factors that are present in Mr. Toro's case that the recommended...
So he was a presumptive risk level 2, is that correct?
That's right, Your Honor. He was on the low end of risk level 2, 85 points, when risk level 2 starts at 70. And there was...
5.
I'm sorry?
5.
Yeah, 75, excuse me. And the guidelines say that there are several things that are present here that can lead to even this risk level 2 being an overassessment of his future risk of reoffense, which is what we're here to do today. It's a forward-looking process about his risk of reoffense. Now, there are factors here, including the fact that no force or violence was used in this case.
How old was the child? How old was the student?
At the time of the incident, the student was 15, Your Honor.
15, and he was the student's teacher.
That's correct, Your Honor.
So even though we're talking about age in terms of lack of consent, we're talking about a 15-year-old child, and we're talking about him having a sexual relationship with her while he is her teacher.
Yes, Your Honor, and obviously...
He's in his 30s, right? When he's doing,
no,
he's in
Your
his
Honor.
30s when he's having this relationship, right?
He was 27, Your Honor.
Oh,
27.
27? Okay.
That's right, Your Honor.
So he's
12 years.
He was 12 years older than Your Honor.
and her teacher.
And her teacher. And Your Honor, no one here is saying that what happened was correct or making excuses for what Mr. Toro did. Nonetheless, Mr. Toro, who has accepted responsibility in this case, has expressed remorse in this case, and who, as demonstrated through his prison record, has worked exceptionally hard to put this behind him and make sure that something like this never happens again. And actually, this court itself in Williams has noted that risk factor 13, simply scoring 0 points for no bad conduct in prison, can still be an overassessment of the client's risk, especially for someone like
But those
Mr.
things were, I mean, just this year, we held that under certain factors, 13 and 15, things like that, rehabilitation in prison, participation in prison programming, family support, employment prospects, those are adequately accounted for in the RAI, which is the first step underneath the Gelati factors, right?
Yes, Your Honor. So speaking of the Gelati factors, this is something that was missing at Mr. Toro's hearing, was the SOAR hearing court never did step 2 of the Gelati factors, or the Gelati test. They never made the determination as to whether the defense had shown by preponderance of the evidence that these mitigating factors existed. Now,
Well, even assuming, so But assuming that in the ordinary course, they're taken into account in 13 and 15, and you have to show something really, really special not to. What did he show that was really, really special?
Your Honor.
He would live with his mom, right?
Well, I think
That his mom moved so that he could have compliant housing. But he was living, where was he living when he committed the offense?
he was living with his mother as well.
So,
then, Your
okay,
Honor,
so there's nothing particularly special, is there, about moving back with the same person who you were living with when you committed the offense?
Was he also living with his mother when he engaged in the other activity in terms of the students having them prepare bombs?
Your Honor, yes. When the students were breaking apart the fireworks for him, that was during the same
During the same period that he was living with his mother?
Yes, Your Honor. And I do think that there is a notable difference between, when you ask what's changed, the fact that he has been convicted, that he's accepted responsibility, that he's done so much work, including 250 hours of class while incarcerated, his current
He was a teacher, right?
I'm sorry?
Was he not a teacher?
He was. And so he's now accepted that that is something that he is not going to be able to go back to, and worked incredibly hard in prison.
I think the whole issue, at least for me, the issue and the reason I brought up his living with his mother, and I think Justice Scarpula as well, is we're talking about supervision. So the argument is now that he's in a more stable environment, living with his mother, who is going to be able to provide some type of supervision. But these were the same living conditions he was in when he had this sexual relationship with a 15-year-old child, and also co-opted his students, to build bombs. But you have time on rebuttal. Thank you.
Yes, Your Honor.
Good afternoon, and may it please the court. Paul Anderson for the people. So the downward departure is the exception, not the norm. And while Mr. Toro is exceptional, it's not for, as Galati and the Court of Appeals has contemplated, and deserving downward departure. So we've heard these factors, but a key factor we didn't hear is any sex offender treatment. And that was something before the court. And so to say that based on his employment history or his promise of future employment, his programming in prison unrelated to sexual offenses makes him less of a risk, that cannot be the case here. And as Your Honor pointed out, People v. William Rivera in the past January, this court rejected or said factor one on gelati, all of these are contemplated. Rehabilitation, lack of trouble in prison, low criminal history.
We also have to weigh those factors with the seriousness of the crime.
Yes, Your Honor, and I think that's exactly what Justice Clancy did here in terms of saying, citing to Santillis, because it was before William Rivera, saying factor one, these are included. She doesn't have to reach factor two because she says, even if we assume that this is proven beyond a preponderance of the evidence, my discretionary review of these circumstances, including this federal offense in which he's exploiting children to build bombs, children that he teaches at the same time, and also that he lives still with his mother and all this, I still are exercising my discretion as the SORA court, I would still not grant downward departure. And so given that this is downward departure is the exception here, and he is a presumptive level 2, the SORA
Does the court, however, need to engage in that step-by-step analysis, or when they found that factor one isn't even met, why even get to factors 2 or 3?
Well, I think
what's the process?
So I think here Justice Clancy was stopped at made the factor one determination, and then just even assuming if factor 2 is met here and that he's shown that he completed his he completed these programs, which he provided certificates, that he has this employment in front of him, that he's going to be living with his mother, even assuming all of that's true, so giving him the benefit of factor 2, the preponderance standard, she still would not have granted that. So here you have these two failings in terms of the presentation of why downward departure should be granted here, and it's enough here. And so, Your Honor, I'd ask that you affirm the determination. Thank you.
Yeah.
Your Honors, I'll be brief. Just on that point about the gelati process, what gelati holds is that all 3 factors must be held, and that's something that simply wasn't present at this hearing. Now, as far as the supervision point that we were discussing at the end, I think a big factor that needs to be considered is, you've asked what's changed. This entire situation has changed.
Did he take sex offender training while he was in prison?
So he did not have the option to, Your Honor, and as—
What does that mean?
He was under federal supervision during this, so as the SORA hearing court noted, he should not be marked for something he was physically not able to do. But he is
And
currently.
you can't take sex offender training in
It
federal
wasn't
prison?
offered to
Oh,
him.
it wasn't
in
offered,
those
okay.
prisons. So he's taking that treatment now. So we're talking about, again, a forward-looking analysis. He's in this post-relief supervision period. So he is reporting to his PO. He is taking the sex offender treatment. He's working at the job that he spent 250 hours while he was in prison to get this job. So there are a lot of factors when we look forward that Mr. Toro is not a high risk of reoffense. We ask
Thank
for a
you.
downward
Thank you
departure.
both.
Thank you. Have a good day.
Chan v. the City of New York.
Good afternoon, Your Honors. May it please the court, Kenneth Gorman for the plaintiff appellant. The plaintiff's notice of claim implied that the defendant was negligent for not placing mats in the second floor corridor where she slipped and fell.
Her notice of claim just says negligence in the maintenance of the premises.
Negligence in the maintenance of the, with regard to water removal?
No, that's what her notice of claim states.
Water removal.
The nature of the, okay. Allowing water and liquid to accumulate on the floor, and then the negligence of the premises. Where does that say mats?
It doesn't. It
So
doesn't
how
say
do
it
we-
anywhere.
So how does that give notice to the city or others that the allegation is that this was due to the lack of mats?
This court's decision in Dones versus New York City Housing Authority is dispositive. We cite that at pages 19 to 20 of our main brief, and we discuss it at pages 6 to 7 in our reply brief. In that case, this court held that the notice of claim, which alleged that the housing authority was negligent for allowing a leaking pipe to leak water, fairly implied that the defendant was negligent for
So
not
the
placing
standard is
mats.
whether or not the allegations go beyond mere amplification or are instead new, distinct, and independent theories of liability. So again, why would this not be a new, distinct, independent theory of liability?
The failure to remove water implies negligent means of prevention, such as mats, and the cause of the accident, the tracking in of water from inclement weather, is fairly implied from the notice of claim. And again, in Dones, they didn't allege mats anywhere in the notice of claim. They just alleged a leaking pipe. But this court said that the notice of claim that alleged a leaking pipe fairly implied that the defendant was negligent for not using floor mats, which was asserted for the first time in the plaintiff's bill of particulars.
But in that Dones case, I mean, there was language to the fact that they left the area unguarded and unprotected. So that, I mean, if to just follow up with that would be like, well, maybe you guard them with mats or something like that. How is that present here? Or is it any time someone says that you didn't, that you were negligent in allowing this slippery, wet condition, we have to infer that also means that you didn't put down mats?
I mean, we could imply it, and it's also based on the testimony. I mean, it's based on the testimony also. I mean, the
No,
defendant.
she said she had no idea what caused her to fall.
That's true. She had no idea.
And you also alleged a defective vinyl floor.
I'm sorry.
You also alleged a defective vinyl floor. What possible notice could you have given about that to say that they didn't mop up the water?
We really didn't argue about the final floor
Yeah,
and
but
appeal.
that's what you did put in your
No, we
amended
did-
notice
we
of
did
claim,
put
which
in-
had nothing,
there's only so
no
much that-
possibility that that was raised before.
We only found out that there was a failure to remove mats when they deposed the defendant's witness in October 2021 and November 2021, and she amended her notice of and she amended her verified bill of particulars in February of 2022. The city never argued.
When did you bring the lawsuit?
2015.
And you're saying you didn't take a single deposition until 2021?
There was issues with regard to discovery that I saw in the NICEF docket, but it's not part of the record, so I really can't talk educatedly
Well, I
about
mean,
that.
so if you don't take a deposition for 6 years, it's not surprising that information doesn't come out, right?
moved
This
to
is
strike
your
this-
case,
I
your
saw that-
obligation to take depositions.
I understand, but he actually moved to strike the city's answer for not producing a witness, and they first produced a witness in 2021. He was diligent, I saw that, I just can't, it's not in the record and was never raised below. But also, before my time's up, the city never argued when it moved for summary judgment that this was a new theory of liability. It addressed the issue of mats. It just said that it didn't have to put mats in this place. However, its own witness testified that it was obligated to put mats in this corridor during times of inclement weather.
I just want to get back to the Jones case. There was an allegation there that the area was unguarded and unprotected from the inclement weather. There's no such, which would lead one to, which again would kind of suggest, the lack of matting. Here, there was nothing about that in terms of a failure on the part of the city to protect the area.
I didn't see the part of being unguarded and unprotected about being related to or the failure to use the mats. I thought it was the failure to remedy the water condition.
Well, that's what the court said, that because the notice of claim had stated that the defendants were negligent in leaving the area unguarded and unprotected, then one could assume that there was also an allegation as to the lack of mats. But here, there's no such statement in the notice of claim concerning unguarded, unprotected, or a failure on the part of the city to protect the area. But you have time on rebuttal.
Thank you, Judge.
Good afternoon, Your Honors. Martin Rowe for the city respondents.
So as a threshold matter, did the city or you at all stating that the notice of claim was in any way defective because it did not talk about the lack of mats?
Yes, Your Honors. As you said, quoted from the notice of claim, it just says negligent in the maintenance of the...
But your friend stated that you never put forth that argument. I thought that's what he just said.
Did you not move to, wasn't your argument that he couldn't amend his notice of claim? Or he couldn't serve the amended bill of particulars?
It was actually that it was not included in the notice of claim
Right.
and that it could not be supplemented in the bill
Right.
of particulars or the testimony because, as I think Your Honors were getting at, it's a distinct theory of liability.
Right. And so the lawsuit isn't over, it's just that theory of liability, right?
Yes, that's correct, Your Honor.
So maybe the plaintiff will be able to prove that you should have mopped up the floor and you didn't, but that's it for a different day. This is only whether you should have fixed the worn vinyl tiles or put down mats. You're saying those two theories of liability are out, and the court agreed with you, right?
Yes, Your Honor, that's
Okay.
So just stepping back a bit too, I would like to point to the appellant herself's testimony that she walked through this very same doorway, the cusp of the doorway where she fell.
She went to get the other parents or who
She went
was
inside
interviewing.
to grab her next folder for her next case, and then she said she was not in there for longer than 5 minutes, and she said, I entered at or around 9 a.m. The actual ambulance call in the record, I believe at page 952, indicates the ambulance was summoned at 9:03 a.m. So at most here, we're talking about a timeline of 3 to 5 minutes, which this court has found, or the Court of Appeals has found in Rivera, that a broken bottle in a stairwell that someone didn't see at 8:30 p.m. the night before and then tripped over at 5 a.m., that was not sufficient to afford constructive notice. We would make the same argument here that this 3 to 5 minute period under especially cases like Rosario, where the period, this court decided last year, the period was 2 minutes. It's just flatly insufficient to expect DOE to have just a constant monitoring, mopping, or matting of an entire facility. And even crediting some sort of general awareness argument that, yes, they're aware that the floor could become wet when it rains, but again, this court last year in Hart said that you still have to have that specific awareness of the condition that's alleged to have caused the injury. There's simply nothing in the record here to indicate that there was any meaningful opportunity for any of the city employees to locate and fix this issue. If Your Honors have no further questions, thank you.
When the plaintiff moved for summary judgment, when the defendant moved for summary judgment, it didn't address the issue of the reoccurring condition, which was alleged in the plaintiff's bill of particulars. In David versus New York City Housing Authority, this court held that the defendant failed to meet its burden on summary judgment for not addressing the same allegations that the plaintiff raised here, the failure to correct a reoccurring condition, which the defendants admit was the case. I mean, Mr. Robert Alvira stated that rugs had to be used in the lobby during times of inclement weather, actually all floors during times of inclement weather, because
But
water
again,
would
you didn't raise the rug. The rug is out. So the question is whether the general knowledge that when it rains or snows, there are puddles.
and they admitted that.
Can be used to imply or show specific constructive notice on this day in this case. And there are a lot of cases that say it can't. So I want, what do you have to sort of distinguish them?
One last point is that in all these cases where they established lack of constructive notice, they established that they inspected the area
Well,
within
he
a
did
reasonable
inspect
time.
it the day before, right? He said he inspected it the night before.
The night before, he didn't inspect it any time during, when he
The day
got
before.
there. He admitted
right?
that
The
he did not-
logbooks show that it was inspected the day before.
the day before, but
Right, at night, the night, he
night.
writes his logbook at the end of the day and said, I expected. And this happened the next morning, right?
yeah, well, that's correct, the day before, but he never inspected at any time.
Right, he says he's cleaning up
morning
the
of the accident.
snow while this is
Right,
happening.
He was outside, cleaning up, shoveling the snow.
Well, he's saying that it was a tremendous snowstorm. that
Exactly.
day. But the weather report from the plaintiff's expert established that there was no snow that day. It snowed on January 2nd, January 3rd, 4th. I mean, there was a trace precipitation on January 5th, but there was no snow on
Well,
January
this is
6th.
January 6th, so, I mean, he's still dealing with the snow. But anyhow, he stated he was outside, and yes, he had inspected the day before.
I don't think an inspection the day before suffices with regard to 9 o'clock the next morning. When he was
The
there,
logbook says he looks at before he leaves the night before, and there's nothing there. And 9 o'clock the next morning, while he's outside shoveling the snow and people are coming in and out, you're saying that that is not sufficient?
When
said it
she
was his-
falls at 9 o'clock?
He said it was his practice to inspect every floor before people started walking. At that time, during the morning, he inspected every floor. He just didn't do it that day. And there's an issue of fact as to whether it was snowing at that time. The plaintiff established that it wasn't. So inspections should have been done. He admitted they should have been done, and they were not done. And that, because they were not done, they failed to meet their burden with regard to the issue of constructive notice. Thank you very much.
Thank you both. SC Property Development versus MW Capital.
Good afternoon, may it please the court. William A. Thomas for appellant. I'm not sure how much procedural history your honors are interested in hearing. I think this appeal boils down very simply, fundamentally, to the idea that the prior dismissal of the action was not on the merits.
Why? Why was it not on the merits?
Well, there's no indication in the order.
Well, it doesn't say on the merits, right? That is clear. It doesn't explicitly say on the merits, but everything else about it would lead one to understand that it was on the merits.
Well,
Let's just take one step beyond that. There was no opposition.
That is
to that
correct,
motion,
Your Honor.
right?
Yeah.
That is correct, and that was no one's fault but mine. The question is whether I could then employ the saving statute of CPLR 205 to recommence within 6 months.
And do you agree that if the court granted the motion under 3211A1, which is a merits dismissal, then you couldn't?
If
And
that decision was rendered under
right.
3211A1.
And the plaintiff moved under 3211A1 and submitted the settlement agreement and other documents,
Both
right?
3211A1 and 3211A7, but 3211A1.
Right. And so the core question is clearly whether or not
And it says, on these documents, the court's statement is, based upon the foregoing documents, which are the 3211A1 documents submitted in support of the motion to dismiss the complaint under 3211A1. So why should we not assume that that's a dismissal on the merits?
because the dismissal under 3211A1 was only sought on behalf of defendant MW. I went into this at some length in our reply brief. The dismissal against defendant Wang, who is the respondent here, if you really look carefully at the underlying motion to dismiss in the original action, was only sought under 3211A7.
So on July 27, 2022, the defendants, including Wang, did not move for dismissal under both 3211A7 and 3211A1? Because that's what I have at record for record 49.
The notice of motion simply identifies both statutes. The defendants will seek dismissal under both those statutes. I believe that's reiterated in the supporting affirmation of
But not just that, right? There are documents.
I'm sorry?
A 3211A1 has to be supported by documents, and there are
There are
documents.
two documents.
The two documents are the settlement agreement and the employment agreement.
And the signed release, the release between Wang and
None of those, I'm sorry to interrupt, Your Honor.
the signed release. So we have the employment agreement
Right.
as well as the signed executed release.
And those two documents don't go to 3211A7, they go to 3211A1.
I would like to be able to tell Your Honors why they do not.
Please do.
Okay. The settlement agreement, first of all, was not with Wang. The settlement agreement was with defendant MW. It had nothing to do with Wang. The employment agreement, the alleged employment agreement, was not as between SCPD. It was with another entity with which he was also employed. And the termination agreement you mentioned, again, that only pertained to defendant MW. The question is, did they use any of those documents? Did they rely on any of those three documents? Indeed, could they possibly have relied on any of those three documents in seeking dismissal vis-a-vis Wang? The answer is clearly no. And the way you know this, Your Honors, is by going to record page 93, which is their actual memo of law on the motion. This is where they go into it. And if you look at that section of their memo of law, which is the only section discussing the basis on which they were seeking dismissal as against Wang, or dismissal on behalf of Wang, it's very clear that, yes, they mention the employment agreement. However, the point heading speaks for itself. It says, the complaint fails to state a cause of action against Wang. And I put it to the court that their argument in that context, and this is, again, pages 93, 94 of the record, couldn't possibly be construed to be seeking judgment based on documentary evidence, even with respect to the employment agreement in question,
So
for a
you're
variety
saying
of
they
reasons.
just put them in just for fun?
It's the only document they even mention in this context. The document does not pertain to
I'm
employment with
asking you,
plaintiff.
why would they have put them in if they were only moving under 3211A7,
But when you say
which is
them,
directed
or when you
only to the complaint?
When you say them, you're referring to all three of those documents?
Whatever documents they put in under 3211A1,
Again.
which you didn't respond to.
The first two of those were clearly put in only with respect to defendant MW. The only one put in with respect to defendant Wang.
So, counsel, are you arguing that the documentary evidence that was submitted was insufficient for the court to make a ruling as to the 3211A1?
It's certainly-
Or are you arguing that it should not have been put in at all?
Both.
Or the fact that it was submitted does not make it a 3211A1?
It would have been insufficient for the court to have adopted it, and they barely pretended in the very context in which they were arguing on behalf of Wang that it would have been. In fact, they make no claim. They don't use the phrase documentary evidence in that context. They can't possibly pretend and didn't pretend that it would have been sufficient.
So then isn't your remedy to move to re-argue?
Yes.
Right?
Because if
That's
you're-
your remedy.
If you're stating that the court should not have relied on those documents in rendering its decision because somehow those documents were deficient, then it would be a motion to re-argue.
I'm saying again that the facial content of the decision itself presumptively renders this a decision not on the merits. It doesn't say what statute.
I didn't understand what you said, but that's okay.
But there's
you have
nothing
time on
in
rebuttal.
the order doesn't say what the statute.
You can repeat it on rebuttal. Thank you so much.
Good afternoon. May it please the court, D.L. Morris on behalf of the respondents Jun Huang and Highwater Capital Group LLC.
I mean, Counsel, you have to admit that the 2021 order is very vague. Well, I don't want to say vague.
Brief.
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 Yes. It doesn't even reference a specific section of 3211. Are we reading too much into it?
I don't think the order has to reference a specific section, as we briefed in our response, the order doesn't also have to expressly say on the merits. The order does reference a number of documents in the underlying record, including the memorandum of law.
Let me just start and ask you, did you move under 3211A1?
Your Honor, it was under both 3211A1 and 3211A7.
And do you agree that the court granted it on all grounds, right?
I do agree with that position,
And
Your
a
Honor.
3211A1 is a decision on the merits.
That is correct, Your
Would
Honor.
not permit someone to use the saving 6 months period of 205A.
That is correct, Your
We're
Honor.
both we're on the same page with that.
And I respectfully disagree.
And can we agree also that Wang also moved for dismissal?
That is correct, Your Honor.
Okay.
And just to correct the record, in the section cited by counsel with respect to the 2021 motion to dismiss, there's both the termination agreement and the employment agreement that are referenced in that section as a basis. Part of the argument that the underlying counsel is making is that we don't exactly understand what the plaintiff is trying to plead here. That's separate and apart from our arguments on standing related to the bankruptcy case, even based on counsel's own admission right now that the contract was with Suzuki Capital, not Suzuki Capital Property Development. But separate and apart from those points, counsel argues if he's trying to argue breach of contract, he can't make that claim because here's the facts. And he references the employment agreement. And if he's trying to also argue theft of a corporate opportunity, you can't make that claim because look at the termination agreement, et cetera, et cetera. So on those bases, and as cited in the 2021 dismissal order, referencing every section of the underlying document, the underlying record, the court was well within its authority under both 3211A1 and 3211A7 to say this is a dismissal on the merits. This also underscores the fact that in the dismissal order, the court references the 2 adjournment requests that have been made by the plaintiff in that action, despite never filing a opposition to the motion. So based on those 2 adjournment requests that were never fulfilled with actual a pleading, the court entered a judgment. And as you might note that the box checked on the order actually was for the case disposed. There was no other.
Right, directed the clerk to enter judgment in favor of defendants.
Correct, Your Honor. And so what we try and underscore in our pleadings is that this is actually the 3rd time Huang's employment contract is being litigated in these courts. The first was with respect to our 2019 suit where Huang filed a lawsuit against Suzuki Capital saying you didn't pay me what you were supposed to pay me under the employment agreement. That got wrapped up in a bankruptcy proceeding that during that bankruptcy proceeding, SC Property Development tried now twice with both the 2021 lawsuit and the 2023 lawsuit to file a claim based on breach of Huang's obligations under the employment contract, among other claims related to corporate theft and opportunity. All of those issues, we believe, were rightly reviewed by the judge in both the 2021 litigation as well as most recently with dismissal in the 2023 lawsuit. And I will reserve time for any other questions.
Thank you.
Thank you, Your Honors.
Again, clearly, seems to me the focus of the court is whether this was a dismissal on the merits under 3211A1. Counsel's correct the prior decision doesn't specify the subdivision of 3211. He fails to mention, it doesn't mention 3211. In fact, it doesn't mention any statute whatsoever. But going again to the heart of the question, whether or not they were even purporting to rely on any of those three documents as a basis for a dismissal, I suggest that their memo of law in that context leaves very little doubt that they were not. I would just also say, as far as the termination agreement and settlement agreement are concerned, again, those could not possibly have been relied on as a matter of law, and it's difficult to believe that the judge in the original action was doing that in that context. I understand it was unopposed, but I think extrapolating that from this of all decisions, that order would really be a tall order. The fact is, the termination agreement, as we allege in great detail in the subsequent complaint, was entered into as a function of Wang's fiduciary derelictions. I would just lastly point out that Highwater Capital was not a party to the original action. There's no reason for them to have been dismissed unless there was, in fact, a statute of limitations defense or some other defense. It certainly wouldn't have been res judicata. This is a separate party. We basically said, assuming that they might have been moving for on statute of limitations ground, and that is not identified in the order appealed from, then either there would be a relation back under 203C of the CPLR because of unity of interest, or more to the point, it would have been timely under a 6-year statute for unjust enrichment. I mean, if you
Thank you.
we
Thank
asked
you
for
both.
disgorgement. Thank you, Your Honors.
Wong v. Wong.
Good afternoon, Your Honors. Seth Weinberg for the defendant appellants. And I'd like to begin with our position that the trial court incorrectly relied on EPTL 10-5.1 as opposed to 10-9.1. And the reason for that is 10-9.1 is the statute that deals with exercises of powers of appointment, which is what we're talking about in this case, particularly grandmother's 2017 power of appointment. That statute says if the document is silent as to revocability, it is irrevocable. And if it is irrevocable, the documents grandmother executed subsequent are void, and the trial court erred in not reinstating Dixon and Erica as trustees and beneficiaries of the trust. Concerning...
Well, what about the trust documents themselves? The trust documents say, right, don't they, that the trustors, I guess, the people, the testators intended to retain the power to appoint and change trustees, right? Isn't that right in the trust documents?
So what the trust says is they have the power...
Article 2C and 8K, do they not both say that the testators intend to retain the power to do that?
Yes, but when they... So that's the question of what happens when they execute that power. And when you execute the power...
Why doesn't that satisfy EPTL?
Because the EPTL, there's two different statutes. That's 10-5.1 deals with when we're at the trust stage. Now we're at the stage where the trustor has now turned into a donor and made themselves a donee to authorize the power of appointment.
Well, isn't the donor here the testator?
Yes, but they wear different...
So that is there. So if the testator and the donor are the same person, and the testator in the trust document says, I retain the right to do this, then why isn't that satisfied?
Because EPTL 10-9.1 says when a donor does this,
The donor and the testator are the same person.
they don't have to be.
Oh, I agree, but they are in this case. So we're looking only at this case.
No, I understand, but the EPTL is concerned with once you move from stage to stage, your status changes.
No, I don't know, I don't agree. You're saying that they have to have a separate document?
Yes, they have to exercise the power of appointment.
Show me a case that says that.
There's never been a case in 100 years.
No,
that
there's
interprets
no
this statute.
case that says that because that's illogical.
It's not, Your Honor, because if it is, that means 10-9.1 is meaningless.
Why would you need a separate document?
Because you don't need a separate document. The grandparents could have done nothing. They could have never executed a power of appointment. They did. And once they did, there's a statute that governs that situation. And when it did,
Why can't they just assume that because when they were the testators, they manifested this intent, and they have never unmanifested this intent, that the intent goes forward with when they're doing their donating?
because when we're reading the legislative statutory scheme in whole, we have to harmonize it.
Yeah, I
to
think
do
this
that-
totally harmonizes it. Maybe if there were two different people and they hadn't expressed that intention in the trust document itself, you might have a better argument.
Well, but the statute says in exercising the power of appointment. That's what 10-9.1 says. It says when you execute this document, you must do this thing. So you read that out of the statute by saying, I have to go to another document to get intent. The legislature made a policy decision, which is we're going to look at these documents separately. We've enacted separate documents, separate statutes for each one. And at that point, we have to read them together. And the grandparents could have done many things. In fact, in the execution, they could have said it's revocable. They didn't. So we have to read the statute, otherwise we're saying 10-9.1, the provisions that require it to be in the document have no meaning. So we can't do that. And before my light goes off, I'd like to briefly talk about the shares that were transferred to Dixon and Erica and were done in the prior litigation as part of the settlement agreement. In the prior settlement agreement, Steve promised he would not challenge Dixon's and Erica's ownership.
In his individual capacity,
Right.
correct?
Well,
So is that not the distinction? Is that because that was in his individual capacity?
so I would say, again, this court has not spoken to it one way or the other, but the second department has. And what the second department has said, we would ask this court to follow, is when the fiduciary and the individual are the same person, are going to get the same
I
benefit.
think the Court of Appeals has said something else.
The Court of Appeals has not said it when it's the same person getting the same benefit.
I
It's a
think the
separate
Court of
circumstance.
Appeals has said that if you enter into a settlement agreement in your individual capacity, that does not bar you from bringing a subsequent lawsuit in your representative capacity. I mean, you mention it in your brief, and you say we should revisit this issue.
No, what
right?
I was
That's basically what you said.
No, Your Honor, respectfully. What I was saying was the Court of Appeals was dealing with a situation where the individual and the beneficiary in the two actions, it wasn't to benefit the same fiduciary. At the end of the day, in those cases,
Why is that the difference that makes?
because what you're doing in those cases is you're allowing the fact that, in this case, particularly when it comes to grandmother's trust, that grandparents change their mind later, that now Steve can get the benefit he promised he wasn't going to get. And particularly when Steve is trying to enforce the settlement agreements to do things like keep the property that were taken out of trust, to avoid grandfather's power of, he's trying to gain the benefit, and he's trying to gain everything he said he wasn't going to get.
No, not on his own behalf, on the behalf of the trust, right? He's acting in behalf of the trust.
To transfer it to him. And that's what the second department distinguished those Court of Appeals cases by saying he's not really acting in the benefits of the trust because all the assets are going to him at the end of the day.
As the beneficiary?
Exactly. He's recouping, he's clawing back the shares to bring them to the trust to give them back to him. And so he's
They
using,
never revoked the trust.
grandmother did.
I have one question. The trust was created in 2016?
Correct.
And then those shares to Dixon and Erica in 2017?
Correct.
But if the shares are already in the trust, how can they still go to Dixon and Erica?
Two answers for that. And so number one, if the court finds that grandmother's subsequent powers of appointment are void, then they would pass to Dixon and Erica through the trust.
What if we don't?
And if you don't, then it's back to that, which is parties can chart their course in litigation. And the parties charted their course. Steve, in the prior litigation, specifically said, I alleged that these shares were given to Erica and Dixon improperly. I want a constructive trust. We then settled the case so he would bar himself from challenging it. And now we're saying, no, Steve gets the shares back, and he said he was not going to challenge either Erica's ownership, Dixon's ownership, or the trust's ownership.
We're not saying Steve gets it back. We're saying the trust gets it back.
And then the trust is going to give it to Steve because now he's the beneficiary again. And that's what the second department hinged its hat on when distinguishing those
The
Court of
beneficiary
Appeals
could have been changed, right?
I'm sorry?
Beneficiary could have been changed.
Well, again, it depends how you read EPTL 10-9.1. But yes, but in other words,
So it didn't necessarily have to go back to him.
well, it does when you accept his argument that he was changed back to him. If it wasn't changed,
At some point it was, but I'm saying that you're saying that makes it sort of like a dirty deal, but
was
it wasn't a dirty deal if it went to somebody else. It just went back into the trust.
well, but
I
again,
mean, before the person, I think one of the people, one of the testators didn't die till 2022, right? That could have changed any time.
well, that's a grandfather's trust. That's separate. We're not
Or the
litigating.
grandmother's trust. At the time this happened, was she already passed away?
At the time when you say this happened, Your Honor,
2018, was she passed away?
I don't recall if she
So
passed
she
away.
could have changed it and
She
changed
did. She
it to
changed it
anybody
back to
else.
Steve, and that's when he commenced
Well,
the litigation.
okay,
And then she passed away.
But then she could have after she changed it to she could have changed it back. I mean, she changed her mind a lot, right? And she could have done it again.
And that's why I would suggest you not circle back, and I'll sit down. That's why the EPTL says you have to be very clear and say this document is revocable. Otherwise, we're debating what silence means.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Bruce Letterman, and you've hit on three issues that I want to present.
Can you start, please, with the part, with the trust being created in 2016, and then the shares to Erica and Dixon in 2017? Understanding that, but in terms of the settlement, Steve waived any right to these shares?
Steve, in his personal capacity, that's correct. Steve is not a party plaintiff. It's Steve Wong as trustee. The entities that brought the case are the trusts. And Mr. and Mrs. Wong, derivatively, on behalf of Wei Lun. Steve is not a party. His name is the first name, but only as trustee.
And who's the beneficiary?
I'm sorry?
Who's the beneficiary?
As we speak now, it was Steve.
Steve.
But you're all going at the same time, and you're all hitting on all these issues. So to all of your points, that could have changed anytime. The power of appointment springs from the trust agreement, which is clear in all of its terms that are recited in the briefs. I don't have to repeat them here. That Mr. and Mrs. Wong wanted to retain control over what was happening to the assets that were in the trust. The 2017 powers of appointment, changing Erica and Dixon to the beneficiaries and the co-trustees. I missed this in my brief, and I apologize for this. But I'm looking at 10.9.1. So counsel's whole argument rises and falls on 10.9.1, where they basically argue that unless that 2017 power of appointment signed by mom, Mrs. Wong, I don't mean any disrespect, said that she reserved the right to do further powers of appointment, then after that, no matter what anybody said, did, or anything else, you couldn't do it. You couldn't change it. As a matter of fact, that
But
was their position.
doesn't that contradict the terms of the trust?
It contradicts the terms of the trust, and it does not comply with the requirements of 10.9.1.
So wouldn't they
And I
have had
missed
to
it.
change the trust?
10.9.1b, where it said, the only place where I see in the statutory scheme the exercise of a power of appointment that must say that it is whenever an exercise of power of appointment is irrevocable whenever the donee does not manifest in the instrument exercising his power, his intention to reserve a power of revocation. That's the only place where I find the actual requirement that I specifically do not intend, except what I missed. That's the donee. That's a secondary giving. The donor is not the testator because they were very much alive. The trustors were the donors, and the donee, in the case now, is Steve. Steve was the original donee. So if Steve, as donee, wanted to exercise a power of appointment and give something to somebody, he had to say in that document that it is my intention to reserve
Can the
a power
donee
of
do that?
revocation. Pardon?
Can the donee do that?
Yes, under the trust documents, he could. The donee could then make further appointments.
okay.
Okay, so they could do that. So that's what I missed, and I
Well,
apologize.
the argument is that Steve is able to accomplish as the trustee under the, he is able to accomplish as the trustee what he was not able to accomplish individually.
Well, you could say those words, but he couldn't because Mrs. Wong passed away in 2021. This is 2018.
Grandmother,
Grandma passed away in 2021. Grandfather passed away in 2023.
Right.
So for 5 years, 3 years and 5 years respectively, Mrs. Wong and Mr. Wong could have changed anything they wanted to. They could have gotten rid of Steve again as trustee. They could have changed the beneficiary. They could have done anything they wanted to, but they didn't. So the case that counsel cites for the proposition that, that I think it's Scungillo, I'm going to screw up the name because it's not in front of me. Scungillo, I think. It's a Second Department case where the issue was as against executor of estate versus executor of estate. Everybody in that situation was dead. Nothing could be changed. And in that case, the plaintiff brought the case individually and as testator of. So both in a representative capacity and a personal capacity. And that holds true for all of the cases cited within that case. That is what they rely on for their support. With the estates, there is no change. They're dead. They can't change anything, which is unlike our case.
And there was actually a 2020 transaction, right?
Yes, there was.
So,
But what happened
they had
was
the power to move
the
stuff.
powers of appointment in 2018, Mr. and Mrs. Wong both signed powers of appointment that reappointed Steve as trustee and as beneficiary. And then in 2020, they each signed, and each one of these documents was translated by a Fujianese for dad and a Cantonese interpreter for mom. Unlike the 2017 documents, which were not translated to Fujianese for the father by anybody, never any claim that they did. In 2018, they put Steve back in place. And then in 2020, one of the assets of each trust was a 25% share in a condominium on Bayard Street and 25 shares of Weilun stock.
They take that out of.
So in 2020, the 2020 powers of appointment directed Steve as trustee to transfer the 25% interest in the condo and the 25 shares of Weilun to himself personally. We did the deeds. That's part of the record. The deeds were done. The deeds, the real estate deeds, were done. But we made
Not the dirty deeds.
We made a demand because Dixon had assumed the presidency, and he was the one with the corporate book. So we made a demand on Dixon and Erica to issue the shares of stock, cancel the ones in the name of the trust, issue them in the name of Steve. They refused. We started a separate lawsuit. It was all sort of tied up into one. Now, the challenge being, what Your Honor, the Judge Weber, what you said about wasn't he really doing indirectly what he could do directly? Again, the trusts were not enjoined from doing anything. And the trusts were parties to the settlement agreement. Dixon and Erica signed both personally and as the then trustees of both trusts. There was no prohibition, which there could have been, I guess, if they wanted to, maybe, and I don't want to say anybody's out-lawyered, but if they wanted to, they could have put a prohibition in there that neither Steve nor Dad's trust nor Mom's trust could challenge their ownership. And lastly, if I can, I know I'm way over time, the shares of stock, there's an argument being made on the appeal for the first time, was never raised below, that something other than certificate number 2 is what Mom had the shares of stock through. And there's a case they cited, Second Department, Jelly against Jelly, if I'm pronouncing it correctly. And then they try to support that with information or words from affidavits that Judge Crane had declined to allow or declined to admit because of hearsay. So what you have is the only basis for which Dixon and Erica claimed personal ownership of 25 shares each was that we had the stock certificate number 2 dated November 1, 1978, that supposedly was the original issued share that mom had 50 and dad had 50. Mom never had 50. And what we proved at trial through Jeffrey Luber's expert report and a ton of exhibits and checks that were written over the years, decades, is that grandfather didn't sign his name with an uppercase print G as he currently did, and for the last, as long as I knew him, that's how he signed his name. But back when, he used a cursive lowercase g in his signature. You had that situation. You had the fact that the trust themselves say that all of the shares in Wayloon are being deposited into my trust. And you also had the fact that the whole purpose of these trusts was to allow them to qualify for Medicaid.
Yes.
And if Mr. or Mrs. Wong owned 10 shares in Wayloon, which owned a mortgage-free property on Christie Street, free and clear, they would not, neither one of them, if either one owned shares, neither one would qualify for Medicaid. That's the whole purpose of the trust.
Thank
So
you.
when,
Thank you very much.
Thank you.
I'd like to begin with counsel's first point that Steve is the donee. He is not, and I know he's not because donor and donee are defined in the statute, the EPTL 10.2. The donee is the person the power to make an appointment is given to. An appointee is the person in whose favor the appointment is exercisable. So Steve is an appointee, which is not mentioned in 10-9.1. As my colleague just said, 10-9.1b specifically says a donee cannot exercise a power of appointment and make it revocable unless they explicitly say so. So the only way they get around that is to ignore it and say, well, the trust says something different. I don't think the trust gives that power, but even if it did, the EPTL doesn't allow for it. Concerning share number 2, I don't know how counsel can say we never raised it. It was the whole thrust of the trial was grandmother had these 50 shares. And our point was that a stock certificate in and of itself is not the only way to prove ownership. And that's from this court, the second department, the third department, the fourth department, everyone agrees. So our point was there was other evidence, and Judge Crane found, factually speaking, that grandmother did have those shares. And the affidavits, I know Judge Crane didn't consider them, but I would submit those were an error. She said they're hearsay. But as this court has found, affidavits of decedents are admissible as party admissions, regardless of whether they're adverse to the decedent's interests. So we have all these affidavits where grandparents said, this is what we did, this is what we intended to do, and this is what we wanted. And yes, they changed their minds later. I'd submit they can't.
I mean, they changed their minds. So even if she did have it at some point, we start from the end, right?
But you can't change your mind to the extent you already gave the property to someone else. And that's why it has to be irrevocable, because otherwise what you're saying to the—
I honestly don't agree. I don't know how you can say that you can't mesh the two together. Meshing the two together definitely does not make one superfluous.
Well,
it just makes them both, operative.
I can only say, and then the light's on, the document specific, the statute says it must be in the document.
Thank you.
Thank you.
Both.
Your Honor, can I just?
No, but thank
I thought
you.
I reserved 2. There's 2 different ledgers.
Oh, yeah, that's right.
Did
He has
you?
a
I'm
cross
sorry.
appeal.
Yes, you did. I apologize.
I'm sorry, Your Honor.
No, it's my mistake.
There are 2, first of all, I didn't say they didn't raise certificate 2. What I said was that's only what they raised in terms of ownership. They never claimed ownership interest any other way.
But
Grandma had
does it
50.
matter? Because at the end,
At the end, it may not matter, okay? And Judge Crane's confusion in ruling on my cross appeal from
doesn't matter.
that there were 2 ledgers. One that was used on the day the trusts were created that show 50 shares issued to father, then that canceled, then 25 to each of the mother and father, then those canceled, then 25 to each trust. That's how they issued the stock. Certificate number 2 is the only thing they relied on for ownership, and it was a forgery, and Judge Crane properly found that. Thank you, Your Honor.
Thank you.
Oh, I'm sorry, do you have any other questions? Nice to see you.
Flowers v. District 37, DC 37.
Good afternoon, Your Honors. May it please the court. Sandra D. Parker for the plaintiff appellant Swain Flowers. In this case, Mr. Flowers was not challenging the union's right to decide whether a grievance was or was not meritorious. What Mr. Flowers raised in this action was that the union, and specifically one of the delegates, Mr. Henderson, engaged in misleading and dishonest conduct that led to Mr. Flowers being deprived of the right to pursue his grievance. However, the court below construed the claims and the issues as one where Mr. Flowers was allegedly challenging the union's right to decide whether it should or should not pursue a grievance. And the cases which the court cites indicates that pretty much is the premise on which it decided that the union did not engage or did not breach its duty of fair representation. For that reason alone, we believe that the decision below should be reversed.
So the court misapprehended the facts or the law? Or
Both, Your Honor, because in this case, this is a summary judgment case, and we put in detailed affidavit from Mr. Flowers indicating the nature of the misleading conduct in which...
Was there a motion to re-argue on this?
No, Your Honor. Indicating the misleading and dishonest conduct in which the union and the delegate engaged. They moved for summary judgment. They did not dispute any of the allegations in that affidavit.
Counsel, may I ask you, right, you didn't sue the individual delegate, right? You sued the unincorporated.
union,
Right.
yes.
And so there has to be, in that situation, there has to be an allegation that all the members of the union authorized and ratified this conduct. And you didn't make that allegation because this is an unincorporated association, right?
Your Honor, I would suggest that that issue, to a certain extent, is irrelevant. And the reason it's
Well,
irrelevant...
but you didn't sue the individual.
That's correct.
Right? So there's no claim against him. The only claim that you have is against the union.
That's correct.
And the union, the union can't be sued unless you show that.
Yes.
That's the law. We didn't make it up.
Yes, but
that is.
I'd like to address...
So how did you show that, I guess is my point.
We didn't show that, and my argument is we did not need to show it. In other words, there are two causes of action. Breach by the employer, H&H, of the collective bargaining agreement. In order for Mr. Flowers to pursue that claim, he must exhaust the administrative remedies under the contract. However, there's an exception of futility. The futility premise is if you can show that the union breached its duty of fair representation, then you need not exhaust it. Now, you don't have to sue the union.
So how do you...
You don't have to sue the union.
But you did sue the union.
Yeah, but even if, as Your Honor points out, that you can't pursue a cause of action against the union.
Right, it's the Martin, I think it's the Martin rule is what it's...
Yes, the Court of Appeals case in the Martin decision.
Right.
We cite cases which say, in terms of pursuing the employer for breach of the collective bargaining agreement, you can sue the union alone, you can sue the employer alone, or you can sue both.
May I ask you, wasn't he told that the union wasn't going to proceed with his...
No, he was not. And there's no affidavit that was submitted in support of the summary judgment motion indicating that. Mr. Flowers put in a detailed affidavit specifically stating that, first of all, no one told him that the union...
I thought the president of the local said, I told him I wasn't going to do it.
There's no affidavit to support that proposition.
Well, but it's true, but he could still pursue a grievance without going to the union.
That's correct, Your Honor. And our,
But he did not do so, right?
our position is he did not know that he could do so.
Had he done so in the past?
Never,
He never brought up
never.
grievance?
But the collective bargaining agreement states that he can do so.
That's correct. However, we cite cases, first of all, we submit that he did not know that, number one. No one from the union told him that, number two. And number three, they had an opportunity to say, look, we're not going to file it. There's no merit here. You can do it on your own. And this went on for months, and they did not do so.
Do the union members get a copy of the collective bargaining agreement?
I'm sorry?
Do the union members get a copy of the collective bargaining agreement?
I assume they do, yes.
So he has the information that would let him know that he can bring his own claim.
Yes, but we point to cases, Your Honor, that alone is not sufficient. In other words, where you have a course of conduct for years, and we point that out in his affidavit, even after he brought this lawsuit, the union on his behalf filed a grievance. So there has never been a course of conduct or practice wherein the union invoked that provision and indicated to Mr. Flowers that he could do so on his own. He's a laborer.
I'm just asking you, he didn't testify at his deposition that he had brought grievances before?
The union brought it for him, every last one of them. Mr. Henderson, on his behalf, brought every grievance, and that's not disputed in the record. He never brought a grievance on his own.
Without the union?
That's correct.
Okay.
But he didn't testify that he did so without the union at record A92 in his deposition testimony. Previously brought a grievance against H&H for out of title work individually without the union?
No, Your Honor, he never did.
Okay, I have to pull up his deposition testimony. Thank you.
Good afternoon. May it please the court. Terry Buck, representing District Council 37 AFSCME, which I'll be referring to as the union or DC 37. We ask that you affirm the decision of the trial court in dismissing this action in its entirety on the.
So it's clear as to DC 37 under the Martin rule, there's no issue as to that. What about the issue as to the collective bargaining agreement and his knowledge that he could file a grievance? And what about the issue that he was never told by a representative that they were not going to proceed on his behalf?
As Your Honors noted, the collective bargaining agreement was within his possession, and so he had the information in front of him and available to him to avail himself of that right to file a grievance on his own. But additionally, we would note, relatedly, that the trial court made a fact finding that was not contested in the appeal, that the union had a good faith basis for not pursuing the grievance, and that alone is enough to dispose of every claim against the union.
Do you agree with counsel that he never brought his own grievance? Because I thought that in his deposition testimony, he said that he had brought his own grievance once without the union.
I do not recall, and I would also need to consult the
okay.
deposition. So additionally,
Wait, go back to there was a good faith basis not to doing it, but I think what counsel is arguing is that no one ever told him that.
And they waited for an extended period of time without telling him.
Yes, the email from President Simmons, September 13th, 2013, informed him precisely of the reasons the union was not pursuing the grievance.
Oh, so he was told that they weren't going to proceed. That's what I thought, but I thought counsel said he was never told that they weren't going to.
Yes, Appellant takes issue with the fact that the email did not explicitly say, and therefore we will not pursue your grievance, but it laid out precisely the reasons that the union could not pursue it, which were that there was no possibility of recovery. He was working.
And the union had argued the exact opposite in getting a wage raise, right? So they weren't going to argue against all their other union employees.
And did they say that in the letter that they had actually bargained for something that would be in opposite to what his position was?
I believe so, yes. The specific reason was that the laborer title, the union had recently argued, encompasses the duties of a mason tender, and he was
Which
arguing...
is what he was claiming, that he was working out a title.
And on that basis, the union had actually at this court, at the First Department, been able to have the laborer title matched to the prevailing wage rate for a mason tender. And because of that, even if he was found to be doing out of title work, the only remedy for that would be to pay him the wage of a mason tender, which he was already being paid as the result of that litigation. And we would additionally argue, just with regard to the surprise and prejudice, I would emphasize, as we noted in our papers and previously, that there was no surprise and prejudice. It's clear from the deposition record that both plaintiff's counsel and union's counsel asked, I think, a total of 24 questions directly related to Martin v. Curran and the union's ratification of that decision or those actions. And as well, plaintiff's counsel was also counsel in the companion case, Otero v. DC 37, which decided in 2019, almost 4 years before the discovery period was closed, in which Martin v. Curran was the basis for dismissal of a parallel claim. Thank you, and if you have no further questions, I would reserve my time. Thank you.
Good afternoon, Your Honors. May it please the Court. I'm Melanie West for the respondent, New York City Health and Hospitals, which was Mr. Flowers' employer at the relevant time. As the Court knows, the only way that Mr. Flowers can bring a claim directly against H&H is if he can, for a breach of the collective bargaining agreement, is if he can show that the union breached its duty of fair representation, which is a very...
Do you know whether or not he testified at his deposition that he had...
It's at page 92 of the record, as Your Honor noted. He was asked, have you ever individually brought a grievance against H&H? He answered yes. Did you bring that, or did your union bring that for you? I brought that. That's at page 92.
I thought that's what it said, but, you know, I didn't have it directly in front of me, the quote.
So yes, Your Honor, he had successfully brought a grievance on his own, and that suggests that he was familiar with the process for doing so.
Well, at least it's that he was familiar with the collective bargaining agreement, which would allow him to do so without the union.
Without the aid of his union, that's right. But on the side of you know, the question of fair representation, I would also point to the letter that the union president sent, which was very clear that the union was not going to bring a grievance on his behalf. It addressed his concerns point by point, and that's at page 183 of the record. It speaks for itself as being, you know, a clear communication that the union was not going to pursue a grievance. Of course, a decision not to file a grievance is not a breach of the duty of fair representation, as this court has held, the Second Circuit has held. There needs to be some evidence of dishonesty, deceit, fraud, malice. None of that is present on this record. I don't want to belabor points that my colleague has made, so unless the court has any questions, we ask the court to affirm. Thank you.
I have 2 points, Your Honor.
So, counsel, one of the considerations is whether or not the determination was rational, right? Given the fact that if they had taken the grievance, they had pursued the grievance, that it would have been in total contravention to what the union had already negotiated. Why was that not a rational decision on the part of the union?
Well, Your Honor, I'm looking at the email that was sent, and the email that Mr. Flowers sent in response to the union's email, indicating that the union email omits some of the other parts of the grievances that he wanted to pursue. The Mason tender issue was just one of them. And he followed up and indicated at, I think, A91 and A92 that there was a misunderstanding or not a complete understanding of the nature of his grievance. So that's just one issue. number one. Number two, I'd like to go back to the deposition testimony. And again, I say to your honors that Mr. Flowers is a laborer, and his understanding of a question as to whether he individually filed a grievance does not necessarily equate with the proposition that he filed it on his own
So here's the
without
thing.
the
If
union's
question is
assistance.
if the question is put to you, did you file that on your own, or did you file that on your own? And he says yes, and the question is then followed up with without the union, or the union had nothing to do with, et cetera. Could he not say, I don't understand? What do you mean that it was on my own? What do you mean that it was individual? What do you mean that the union didn't pursue it? I understand he's a laborer, yes, but that does not mean that he does not understand or could not understand a question as to whether you filed it on your own, or whether you filed it with, or whether the union filed it on your behalf.
I understand your honor's reasoning in that regard, but I can only speak as Mr. Flowers' attorney, and with regard to his understanding as to what transpired during that deposition. And I can assure you, your honor, the representations that he made in his affidavit that he never filed a grievance on his own without the union's assistance is accurate and has not been disputed. And in terms of his...
Well, except by him, right? And I will tell you, my father was a union carpenter. He understood exactly what it meant to file a grievance on his own and a grievance with his union. So the idea that just because someone doesn't have a college degree, they can't figure out.
Not at all.
Well, I don't know if he has a college degree.
No.
Maybe he does.
Well, I'm saying this individual.
A laborer does not mean that you are not incredibly intelligent and can figure that out.
And you know, we're kind of going beyond, because when he's given the deposition testimony and he goes over it on the errata sheet, does he say, no, that's not what I meant, that it wasn't? Again, we're going beyond it, but thank you all very much. Have a great day.
Thank you, your honor.
Baton v. City of New York.
Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the City Appellants. Your Honors, the City is entitled to summary judgment here for two separate independent reasons. First, the intersection was reasonably safe as a matter of law, and we know this from
the intersection was reasonably safe as a matter of law. So today is a day for video. Unfortunately, did you view the video?
Yes, Your Honor.
And so, do you see the foliage that is arguably, I don't want to say obstructing, covering the traffic signal?
It partially covered one side of the signal, Your Honor. And in the video at 446 of the record, you can see that the don't walk and don't walk signals are still plainly discernible despite that one branch. We also have the photograph.
We also have the report by your investigator who talked about the foliage, the obstruction, et cetera, which perhaps does not help you that much.
So that's the proximate causation issue. So the Detective Jarvis he opined that the foliage was a contributing cause of the accident. But as we've argued in our brief, because there was no evidentiary basis for that conclusion, it doesn't withstand summary judgment.
Didn't he do the investigation?
He did the
Didn't he go to the scene and take photographs? And there was actually a video taken as somebody approached that pedestrian signal?
Yes.
And at times, it was a little bit obscured, so...
I disagree with that characterization of the video, and Detective Jarvis agreed when he was shown that video that you could see the don't walk and don't walk signals in the video that was taken at the scene of the accident.
He also go on to say that also depends on the time of day and the angle of the person walking. That it's not as simple as taking a photograph after the fact when everything is calm to determine what the decedent saw or did not see when the accident happened.
Detective Jarvis did opine that, and then there's two other things in the record that
And isn't there
show.
a photograph also in this record that shows the sign not illuminated, and it is completely covered by foliage?
There's no photograph taken. The only photographs that I'm aware of that show it's completely covered are the ones the plaintiff submitted that are taken from the end of the crosswalk, which is not the perspective that the plaintiff would be crossing the street. And we know that the signal was visible for pedestrians at the corner for two other reasons, in addition to the photo and the videograph. We have the witness statement, who is standing next to
It was
Baton.
visible to that witness.
Yeah, see, that's the...
Depends on the angle.
It depends on the angle, because the decedent is, my recollection, he was like to the left, I think. And then the two individuals and the female who I think that you're referring to was to his right. Is that correct? That's my recollection. So I don't know what we don't know what their perspective was, the female's perspective was in terms of the traffic control signal. Because it's white. The traffic, my recollection is that it was white, and it continued to say, don't walk.
And the plaintiff...
But he's to the left, so that's what I'm saying. I don't know that we can determine exactly what his perception was, what he saw. And given what the investigator opines, it's questionable, right?
Well, we know that he saw the signal when he stopped at the corner. We see the video, he ran to the corner and he stopped with all the other pedestrians. And the plaintiff concedes that Baton saw the signal at the corner and stopped for it. The entire case now is hinging on, in plaintiff's theory, on whether it became obscured when he took those few steps to the side. And the relevant question is whether it was visible from the corner. And I would point this court to this court's decision in Prats versus Campolo, and also the Third Department decision in Nurek versus Vestal, which say that what matters is whether from the relevant perspective, there's a clear view of the intersection. And here, from the corner, the relevant perspective, there was a clear view. Perhaps if he walked
So it doesn't matter, you're saying that what matters is that there was a clear view from the corner as opposed to where he was standing?
We don't know what he saw from where he was
standing. I'm asking you what you're arguing. You're right, we don't know what he saw.
But from the corner, which is the relevant perspective, yes, Your Honor, that's what matters.
So it's irrelevant where he was standing?
If he'd walked away from the corner, which is what plaintiff is arguing...
Or if he's at an angle that has a different lighting situation, that doesn't matter?
That's plaintiff's argument. But what matters is...
I'm asking you, does that matter or not?
It doesn't matter if the relevant perspective is the corner where pedestrians are waiting to cross.
As a matter of law, you're saying?
At the corner, which is the
you're making that pronouncement as if it's a matter of law in every single case in which somebody's crossing. That's the only perspective that matters.
Or is it that,
hard.
are you asserting that he was outside of the crosswalk? Because I'm not sure why you're even making that like...
If that's the plaintiff's argument is that he walked up the block, and from there the plaintiff speculate that he couldn't. He took a few steps.
Right. It looks. He's still like jogging. The whole thing was that he was jogging, so he's waiting for the light, and so he's continued to move while the light is changing.
And there's two key points here. First, there's nothing to show that from where he walked that the sign was obstructed. Because
that's what I don't know. Because as I stated, from my viewing of the video, he appears to be off to the left. I'm not saying how far from the two individuals he is, but he appears to be off from the left from the two individuals. But
still close to the crosswalk.
Still close to the... But the bottom line is, the city moved for summary judgment. Your own expert, the detective, who was the investigator, states that the obstructed crosswalk signal was a contributing factor to the decedent's accident, noting that the signal was partly obscured by foliage, and that the lighting conditions at the time of the accident were changing because the sun was continuing to go down, which also affected the visibility of the signal. So right there, don't we have issues based upon your own investigators?
No, Your Honor, because there's no support for those conclusions, because we know that Baton saw the signal.
Also, are you denying that this crosswalk had a bunch of foliage in front of it?
Absolutely not. There was a tree.
Right, and so you're saying that despite the fact, because I'm looking at the photo now, it appears to be substantially covered, right, in foliage. So you're saying that despite the fact that you're conceding that there's substantial foliage in front of this crosswalk signal, that it could not have been obscured?
And also despite what your own investigator said. Your own witness said.
The photo at 446 of the record, which was taken at the accident, the 449 of the record, taken at the accident scene, it shows that the don't walk signal was visible despite the
I think what's unfortunate for you is that you have your own investigator maybe not supporting the argument that you're making here today.
but there's nothing to support his conclusions.
But it at
Except
least
a bunch
raised,
of foliage in front of the sign.
But that doesn't, first of all, again, you could still see the walk, don't walk signal. Second of all, there's nothing to show that that one branch, which again, didn't block the
more
visibility.
than one. It's really more than one branch. And I know you're dealing with. It's not one branch. I know you're addressing the photographs, but when you watch the video, the video shows even more in terms of the foliage over the traffic control signal.
The video shows that the crosswalk signal is visible through the branch, though, and we know that it was visible and the pedestrian saw it. And on the proximate
Let me ask you this, and I know the light's red. May I ask one more question? You're now disputing your own expert. Did you put in another expert that said that that my expert I now don't like anymore, and here's another expert that would show?
He was deposed as the police
I'm
investigator.
asking you, did you put in another expert?
There is no other expert
So
testimony.
all we have is your expert, the guy who investigated, the guy who saw the photos, and the guy who made a determination, which now you're stepping back from, but I don't know how you can without another expert who says something different.
Well, we've cited a number of cases in our brief for the basic proposition, which plaintiffs, I don't think have put anything in rebuttal to, that if the expert testimony, even expert testimony, is based, it lacks any evidentiary support, it's conclusory. And here
But
the
it's not, though. Except we have other evidence, the pictures, right? The video.
Maybe
and it's your motion for summary judgment. How do you get summary judgment?
You moved for summary judgment stating that you were not negligent in maintaining the foliage around the pedestrian signal, or that the obstruction of the signal was not a proximate cause of the decedent's accident. Your own investigator says it was a contributing factor to the decedent's accident, and states also that the signal was partially obscured by foliage. Lighting conditions as well at the time of the accident, because the sun was coming down. We have the video, we have the photographs. I'm not understanding. Perhaps you can, you can expound on rebuttal. Thank you.
May it please the court, my name is Matt Geyer. I represent the plaintiff respondent. I know we're focusing on proximate cause here, but I do want to make the point about the hazardous condition. They had another employee of CPC, Mr. Roche Omagne, who took a look at the pictures, the same pictures on pages 1060 to 1064 of the record, and which
He opined that this was something that should have been taken care of immediately.
Right, he said that.
That's exactly what he said, yes, and that's my point. And Detective Jarvis said that those pictures represent the way it looked on the day of the accident. So we clearly have the hazardous.
The issue of proximate cause, what the proximate cause was, right? Your guys, according to the witness, crossing against the light. We have a person who's driving 20 miles over the speed limit, but there's also this. There's this.
And that's what
maybe
Detective
yes
Jarvis
or
said.
maybe not obstruction.
Look, he's an expert. 19 years on the police, 14 years highway safety, highway patrol, 7 years as lead detective in collision investigations. And he came up with 3 reasons: speeding.
What did the witness next? Did the witness who
Was the witness next to, was that a female or was that the male?
I'm not really clear on.
There was a witness that was
was standing next to
But
the.
here's the thing: all the witnesses were okay. So he comes up. The video, we've seen the video, just like the labor law case.
Yeah, unfortunately, we've all
He comes
seen the
up.
video.
He stops. You see clearly. He sees the don't walk sign. This is not an Appleby situation. This is not a Pratt situation because it's a fluid thing. It goes from don't walk to walk. What he does.
Well, it's still blinking when he.
Without question.
When it's still blinking when he starts to move past the crosswalk into the.
But not from his vantage point, because he goes to the
That's
right.
your argument.
That's your
we don't
argument.
know what his vantage.
Oh, no. What we can say, here's what we have. We see in the video he goes to the right, to the far right of the crosswalk. We don't know what he sees. We have these photographs, 1060 to 64, that show as you get close, it's completely obscured. But we can also see from all these photographs, including the video, that the most obstructed area is coming from the right. He's on the right side. We took these photographs 5 days after the incident. We did not have the benefit of the surveillance video, so we did not know where he left from.
But there's one witness who says that he crossed against the light. He crossed against the light.
There's no question that he crossed against the light. The question is whether he knew it. The question is whether he was able to see it, and we have evidence.
Well, he
that the
stopped, right? So there is some evidence, there's evidence going all ways.
There's no question that he stopped, that he saw that it said don't walk, but then he moves to the right, pretty far to the right too, not outside of the crosswalk, not down the block, but far to the right, where the obstruction, this is.
So the question is, what effect did the foliage that's in front of this crosswalk have when he moved to the right?
Right.
But,
Well, that's
vis-a-vis his vision.
That's what we're saying. Because the blockage is on the right side, we can infer, reasonably, a jury could infer, that where he was standing, it would have been more blocked than anywhere else. And frankly, that's the only explanation. Here's the thing.
And they could
It's
also
what
have
happened.
Or
inferred
maybe
that
he just crossed against the light, as most people do in New York City,
But he
right?
but he stopped
He is not
already.
expecting someone to travel 20
Well,
miles.
and that, yeah, that's the other thing. He probably was not expecting someone to be traveling at 60 miles an
In
hour.
part because in the far western lane, the cars in the video are now coming to a stop.
Again,
He's perceiving that.
Bottom line is the city moved for summary judgment based upon the they're not being negligent and/or the foliage not contributing to the accident.
I agree with that bottom line, and they did not establish it. And Jarvis.
Thank you.
Unless you have any further questions.
May it please the court, Donna Brodigan for one of the respondents. I don't want to belabor the points because
I'm sorry, who do you represent?
the respondents from Sharon,
The driver?
the driver. Again, it's our argument based upon the papers that were submitted to the court on summary judgment. Detective Jarvis was very clear in his report. He set out, he went to the scene, he looked at the photographs, he looked at the videos, he walked the scene, he talked to the witnesses, and his final conclusion after his thorough investigation was that it was a contributory factor that branch or leaves were blocking or semi-blocking that pedestrian signal, and that was one of the reasons why this accident took place. It was not all based upon the speed of my car, it was not all based upon lighting, it was a myriad of different things that came about.
But even if we say that, well, he didn't have any real basis to say that, that's still a reason for this to go to a jury.
Correct.
Let them decide.
Yes, I believe the jury should see the video, the jury should hear Detective Jarvis speak about his investigation.
Yeah, I'm sure it's going to be good when the jury sees the video of your driver.
It's a bad.
That's not good for you, but whatever.
With that issue, but since this is not the issue as to my driver today, and it's only about the city, I believe it must go to a jury so that they have the opportunity to hear all of the evidence, hear Detective Jarvis, what he did at the scene, what he saw, who he talked to, and make their own conclusions.
Thank you.
Thank you.
Your Honor, just to go back to proximate causation. So again, we've cited a number of cases on the point that if there's no evidence to establish proximate causation aside from speculation, a case shouldn't go to the jury. I'd just like to point this court quickly to two cases in particular. The Appleby versus State Court of Appeals case. There was a case where there was a stop sign that was missing. The driver knew she had to stop at the intersection, did stop at the intersection, and then went a little bit past, and there was an accident that occurred. And the court said that there is simply no basis at all to find that the missing stop sign was the cause of the accident. That's very similar to the facts here. Also, in the second...
How is that similar? Because here it's not about a missing crosswalk sign, it's whether it changed.
It's similar because here the decedent, he knew he had to stop at the intersection.
Right, and he did. And then at some point he made the decision to keep walking, and we don't know why he made that decision. And isn't it possible, reasonable, likely, whatever word you want to put, that the reason he made that decision is because his vision of the crosswalk sign was obstructed by the overgrowing foliage that was in front of it?
Again, Your Honor, I point this court to the Prats versus Campolo and Nurek case, which say that when the intersection is clear from the relevant perspective, which is the corner, then there can be no proximate causation from a missing or obstructed stop sign. Similarly, the Second Department, Liberty Mutual Insurance Company versus Norton, a very recent case, the court found that when there was nothing to show that a driver failed to stop when there was an obstructed stop sign, whether the driver stopped or not, there was nothing to show that. There could be no basis to find proximate cause from the obstruction. And here, again, the speculation to rule for the plaintiff against the city, there would need to be even more speculation because we know that he did see the sign, did stop.
I'm still kind of, I'm sorry, I'm like focused on this one issue. I know, and I apologize. Does it not matter that the expert, your investigator, stated that the foliage was the proximate cause of the accident? Does it, I mean, in Appleby and all those cases, did you have an expert? Was there someone who said, but for the stop sign not being there, excuse me, that the absence of the stop sign was not a proximate cause? Did you have someone saying, like in this case?
There's a number of cases, Your Honor, in which courts have put aside even expert testimony when there's no evidentiary support. And I would point this court to the Court of Appeals Amatuli case, the Kang Kim case from this court. So there has to be some evidentiary basis. And here,
you don't believe that the photographs of the foliage over the traffic control signal or the video showing it, that is sufficient?
well, when Detective Jarvis was asked about the photographs, he said they show that the crosswalk signal remained visible despite the foliage. And then he did opine that, well, perhaps the lighting conditions could change that. But then he also said, well, I spoke to the witness who said it was clear and he could see the signal. So we know that the signal was visible at the time of the accident from the corner. And that means the crosswalk was
You're saying
reasonably...
unless we have the decedent to say what he saw, that's it, it's over.
Well, we don't need the decedent because we have the photograph, we have the video, we have the witness testimony.
The witness was not standing where the decedent was standing, correct?
They were both standing at the corner, Your Honor. And then the
So
decedent
you're
walked
saying
up
that
the
from
street.
that corner, that it was, according to the photographs, from that corner, no matter where you were standing in that corner, that you could see the crosswalk unobstructed?
We have the photograph and the video in the record from the police investigation that, again, Detective Jarvis agreed showed that this crosswalk was visible at the corner.
Thank you. Thank you all. Carter Bergen III, the Pamplona capital. Think how Manny feels. You gotta be. Whenever you are ready.
May it please the court, my name is Benjamin Margulis from Boyce Schiller Flexner on behalf of the appellants. In granting Appellee's motion to dismiss, the court below committed clear and reversible error. In our briefs, we identified a number of those, but I want to focus on three.
I'm trying to figure out exactly what your argument is or how you've been aggrieved. So you're saying that you made a lot of money, but you could have made even more money if you had known. Is that basically what you're saying? So please give us more money because we should have made more money.
I mean, in part, that is the basis for the damages, in that because of the way that the transaction was handled, in that Pamplona never divulged that it was essentially a front for Russian oligarchs.
But didn't you know that there were Russians that had investments in Pamplona?
Yeah, the other company, I think, which...
William Blair?
Letter one, I believe, is.
Yeah.
Yeah,
And letter one.
Yeah, letter one.
So Pamplona?
That, and also that Alexander Nastor, who was now the CEO of Pamplona, had been the CEO of Alpha Bank, which was a private Russian bank that was owned by Russian oligarchs?
Well, respectfully, Your Honor, and as we argued in our briefs, that goes to their involvement with Pamplona, but not the extent of it, which
You
I
had
think...
a company doing due diligence?
I'm sorry?
William Blair?
William Blair, an investment bank, did due diligence, and also Appellant Carter Bergen reviewed each of the bids that came in. And as we allege, the extent of their involvement was not something that was ascertained.
Now, how did it come about that Pamplona was able to, let's say, merge with or purchase Logic Workers? Was it because of a bidding process and your client took the highest bidder?
Correct. As was just mentioned, appellants retained William Blair, which is a bank that then ran a fair bidding process. Pamplona was one of the bidders. There were 2 rounds of bids. At the end of that process, Pamplona was the highest bidder. Now, one of the things in their bidding letter, or in their bid letter rather, signed by Appellee, I believe it was Battistoni, they said that we are, I don't know what the
Is it
exact...
your position that had you known the extent of the Russian oligarch involvement here, that you would have rejected that high bid?
That is the position, yes. That is why it was a material.
And then what is, with two questions. One, why would they have any obligation to tell you who their investors are? They don't. We all agree they don't. And two, let me ask you this. Did you ask William Blair to go and ask them that?
Well, I would respond to both of those
I just
points.
want a yes or no. That's all I'm looking for. One, what possible damages could you allege from that? Two, why would they have any obligation to tell you that? It's three questions. And three, did you ask William Blair? And I'm really only interested in yes or no answers. I'm not interested in, but let me go to the backstory. I just want to know the answers to those three things.
So to my understanding, let me take them in turn, Your Honor. Was William Blair asked? To my understanding, they were asked to review the bids. Whether they were specifically asked to look at
This is your claim. Did you specifically ask William Blair? Because now you're saying we knew it was this much, but not that much. Did you ask William Blair to find out how much?
I do not believe so, but
Okay, one. Two, what damages did you suffer from taking the highest bid and spending that money and getting that money in at that time? What damages?
well, the damages were the difference between the value of the shares. Now, just to back up, I know you want a yes or no, but I just want to.
I just want to know what you're saying the damages are.
So when appellants entered into the transaction, they rolled over their equity from LogicWorks into Lancer Systems. That's the transaction by which the investment actually
But they didn't have to.
They
They
didn't
didn't
have.
have to. They had the opportunity to do it. So I'm asking you again, what's the damages?
So in so doing, when they rolled,
They made a choice to do that, right?
because they understood or they weren't told about the extent of the.
Which they had no obligation to tell you. We both agree.
With respect, I don't think I agree with that.
Okay, why would they have an obligation to tell you?
They would have an obligation to disclose because when they held themselves out to be, here we go, a global private investment equity firm, that was from their bid letter, and in their press releases in their website, they were saying they served a variety of clients, including public pension funds, international wealth managers.
Is any of that false?
To our mind, as alleged in the complaint, yes.
You're saying they didn't represent all the people that they said they did?
As alleged, they represented the Russian oligarch.
I am asking you, the company, you're saying that they have all those investors, you're saying that was all false? I'll ask your adversary whether any of that was false. But okay.
Well, again, I think there's
I'll
one
ask
more.
your adversary. If you think it's false, okay, but I don't think that's what you allege.
Well, respectfully, Your Honor, I think
Just
that's
keep it in terms of the line of like the actual loss that was suffered. Wasn't there some sort of representation that the company continued to thrive? And then there were further more money from your client to continue to make this thrive?
the company did in fact continue to perform well. However,
Thrive, I think, was the.
Thrive was in the complaint. I'm trying to be a little artful, I agree. But at the same time, in the back end, what was happening was all of these financial consequences began to come due for Lancer Systems, i.e. LogicWorks, because of the involvement of Pamplona, or the extent of involvement in Pamplona by the Russian oligarchs. They couldn't secure funding. JP Morgan pulled its long-term relationship with them, and investors were...
So let me ask you this. Why did JP Morgan pull? And when you went to your bank to ask them for money, what did they tell you?
Are we talking about JP Morgan now?
No.
JP Morgan was their bank.
Right. What did they say?
They said, this is in 2020 now, this is
Right.
after the investment.
After the investment, but before you put in more money, right?
Sort of in the middle. The more money began in 2018.
Did you put in more money after you learned from your bank why they wouldn't give you the loan?
There were additional
You
investments.
did.
afterwards.
You did it. So how could you possibly argue that it was material to you when you put more money in even after you knew?
Well, respectfully, after that, it was a question of keeping the company afloat. The banks were pulling up stakes, so you have to actually keep the company solvent because it looks like we were lied into this situation, as alleged.
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. Justin Orman of A&O Sherman on behalf of the Pamplona entity respondents.
This is the entities that didn't divulge their investors.
So the question wasn't asked, and if I could go back to something that Justice Scarpula said, I think, you know, the plaintiffs themselves have conceded that this is not the kind of information that is typically shared in this kind of transaction.
But you
look,
started off with the question wasn't asked. If it was asked, do you have an obligation to respond?
if it was asked, potentially, and typically in a merger transaction, what you do is if there's a representation or information like that that's critical to your decision-making to enter the transaction, you document it. You put a representation in the merger agreement.
You don't go forward.
Right. Right.
And
That's exactly
also
right.
do due diligence, right? Which is why you might hire a company to go look into that. And maybe your problem is with the company who was supposed to look into that and not the people who didn't divulge it when they weren't supposed to.
The appellants are sophisticated investors. They were represented by an international bank and an international law firm throughout all of these transactions. And
I want to
agree,
ask
would-
you, because counsel specifically drew attention to your bid letter. Was anything you said in your bid letter false?
No, and I would add to that that this is not a fraudulent misrepresentation case.
Well, now I guess it's a fraudulent omission case, right?
It's a fraudulent omission case.
So I guess what the idea is, what you were also supposed to say in your bid letter, not only do we do this, but we also represent these Russian investors.
I don't think that's been alleged. I think if you look at each of the causes of action, there are 4 of them. They are all pleaded as omission causes of action.
Omission, right.
Intentional omission, concealment, those words.
So it's not that anything that was in the bid letter was false. It's
Right.
just that they had an obligation to tell you who their investors were. I don't know where that obligation came from,
But it was never asked. Is that correct?
There is no allegation that that question was asked, and Justice Schechter went over that at the argument below and asked counsel to point her to the paragraphs in the complaint where that is alleged, and they were unable to do that. It simply isn't there. And I think, going back to where Your Honor started, even if they could plead a liability case, which they can't, this whole thing falls down on the damages case. You can't use a fraud.
In New York, the argument that I could have made more money doesn't fly.
That's right. That's Llama Holdings from the Court of Appeals, 88 New York 2nd, 413. You can only recover out-of-pocket losses on a fraud claim. You
So
cannot.
what about the monies, the additional monies that they put in after J.P. Morgan turned them down for the loan, and then they put in I think 10 million. What did they put in?
I was think a little
A $10
north of-
million. They got a $10 million loan and a $2 million revolving.
Yep, I think what Your Honor is referring to are the series preferred units that
Yes.
the appellants invested in. Some of those they invested in after they knew all of this information.
Yes.
They did it anyway because, as alleged in paragraph 56 of the amended complaint, those investments had guaranteed annual returns of between 15 and 22.5%.
Well, they're claiming that some of the additional monies were put in just to keep everything afloat.
Right, but they, in exchange for that bargain, which is documented, they received returns of 15%.
Or did they actually receive that?
Well, there's no allegation that they didn't.
They
I'll
didn't,
represent to you
right?
that
So
they
you
did.
assume that if that was the deal, and they're not alleging that there was a breach of that deal.
Right.
So they actually got the profit that they were expecting.
Right, and who wouldn't want who
Right,
wouldn't
but
want it?
Here, I think you could get 1 or maybe 1.5% on a regular loan.
Right. So, at the beginning of all of this, they walk away with $25 million in cash and $35 million in rollover equity. In 2023, the company is sold. It was sold for $105 million more than its enterprise value in 2016. So you have a 9-figure pocket of profit for everybody to share. And again, as I just said, with respect to the series preferred, annual returns of 15%, the plaintiffs just want more. And the Court of Appeals case law forecloses that from a damages perspective. I would also just say, I see that my time is running out. With respect to justifiable reliance, there's a rollover agreement where appellants acknowledge that they had the opportunity to obtain any information they deemed necessary to evaluate the investment, and that they were capable of protecting their own interests and evaluating the merits and risks of the transactions themselves. That's at 201 and 202 of the record, section 6.3 and 4 of the rollover. Again, the amended complaint acknowledges that appellants were aware of the connection to Russian individuals, yet nowhere do they allege that they or their lawyers or their bankers ever asked any questions about it prior to the merger. And after the merger, they say, we decided not to ask questions about it because it would have been fruitless. So for them to now claim justifiable reliance on Pamplona's silence, I think, as Justice Schechter said, this is one of those rare cases where that fails on the law. Unless your honors have any more questions.
Thank you. Yes, please proceed.
Thank you, Your Honor. May it please the court, I'm Dan Rubenstein, and I'm appearing on behalf of Darren Battistoni. I appreciate the court's willingness to let me be heard today and argue, and being from the second city.
Does Battistoni have any other offenses that were not raised so far? Does he have different arguments?
His arguments are very similar, Your Honor, but I'll make it short. He's alleged to have done three things. First, he's alleged to have signed the letter of intent that we've talked about. Second, after in the fall of 2018 in September, he's alleged to have had a conversation with Mr. Bergen about another company called Device 42 and offered an investment in it to Mr. Bergen. And during that conversation, he raised the fact that there was a problem with it based on CFIUS, which is the federal statute on foreign investment. And because of CFIUS, Pamplona wasn't at that point able to invest. The third point is during a board meeting in November of 2018, he responded regarding Crestline, their lender, and about the possibility of getting the loan, if it got called, getting it renewed. And he offered its opinion on that, a forward-looking opinion. But very importantly, he then left Pamplona in December of 2018 and joined a different private equity fund and had no further involvement. And as the court has pointed out, these are a sophisticated investor who made north of $50 million based on our calculation, and is now here asking the court for more. The damages are precluded, as the court has pointed out, by the New York Court of Appeals decision in Lama, and I won't belabor the points of materiality, justifiable reliance, and the duty to disclose. But
let me just ask this one question. In terms of the 2018, when Mr. Bergen was informed by Bastioni, I don't want to mispronounce his name, that they needed to go through this Device 42 way because of CFIUS, would that be enough at that point to say any action that he continues beyond that is now on him and not necessarily?
No, Your Honor. And specifically, there were no questions. It's not alleged in the amended complaint that Mr. Bergen asked any questions about his investment in LogicWorks and the relationship to CFIUS there. And more importantly, as the court has also pointed out, they continued to invest after that point and he invested an additional $7.6 million after Mr. Battistoni was gone.
But I think what my colleague is saying is, doesn't that kind of put Mr. Burton on inquiry notice at a minimum?
You mean
Mr.
Burton?
Yes, after that conversation, isn't he at least on inquiry notice? If I want to know before I invest $7 million more, after Mr. Battistoni tells me this, I better ask some questions, right? But no questions were asked.
No questions were asked.
I think that's what you were getting at, right?
Exactly correct, Your Honor.
When she says he, she means Mr. Burton, not Mr. Battistoni.
I apologize, I misunderstood your question.
Thank you.
Thank you.
Just want to cover a couple of quick points here. First, my colleague here said that all 4 counts were frauds of omission, which is not accurate. Count 4 is a fraudulent misrepresentation claim, because as we allege in paragraphs 45 and then in 47 and 54, the CFIUS point came up, and that was something that was volunteered by Mr. Battistoni, and then when Mr. Burton specifically questioned Mr. Battistoni about what the CFIUS holdup was and whether it related to anything that would affect LogicWorks, he was told no. This is something that Pamplona was just swept in some anti-China legislation. We're a UK entity, and if we really have to, we can re-domicile and it'll all be fine.
And he doesn't have to go beyond that, just accept that at face value? I mean, wouldn't that be alarming?
Well, that's why he asked Mr. Battistoni, and he was assured by his then business collaborator that, no, you shouldn't be that concerned. We've got it taken care of. And it was something that he continued to obtain assurances about going forward. And that part is at least alleged. I think in listening to Appellee's arguments in part, I'm struck that this is a motion to dismiss. This isn't a summary judgment. So a lot of the questions that came up about what the returns were on the investments and how much appellants knew or could have known or should have questioned are questions that should be answered after discovery.
You know what's interesting? Because I actually went and I looked at the papers, and yes, they put in documentary evidence, no affidavits, but neither did your client. There was nothing from him in opposition, honestly.
No, but then, with respect, they moved to dismiss on two grounds, 3211A7, 3211A1. And in both instances, the only way that the documents merit in favor of dismissal is if they show that there is no claim whatsoever, that they utterly refute the claim, which respectfully they do not. They show that there was questions that could have been answered, but those go to questions of fact that should be explored on discovery.
Even the
you
questions
could
of
have your client could have put in some type of affidavit in opposition.
Respectfully, I think the complaint.
Excuse me?
I think the complaint raises the rebuttal points.
Okay, so we're bound by the complaint. Thank you.
Thank you.
Shulman versus Alliance Energy.
May it please the court, my name is Michael Kazoras from the Law Office of Eric Feldman, and I represent the third-party defendant, Appellant Service Station Vending Equipment, which is also known as SSVE. A non-negligent party, as a matter of law, cannot owe contribution or common law indemnity to any other party. Now, bearing that point of law in mind, there's two key issues that I wish to bring to the court's attention. The first is that SSVE did not owe a duty here to the plaintiff. And second, even if it did not breach that duty to the plaintiff. The mere fact that my client installed an air pump at a gas station approximately 27 years before the accident does not make it such that SVE had a duty to the plaintiff. Okay, the Supreme Court erred in holding that there was an issue of fact as to whether my client's placement of the pump launched a force or instrument of harm. The gas station itself admitted that it was its responsibility to make sure.
I thought it was either. I thought it was a mutual. It was a mutual.
No, the gas station had the responsibility to make sure that the hose from the pump was put back in its place if one of its customers.
We're talking about the placement of the pump itself.
The placement of the pump itself, there's some ambiguity about the testimony.
And right, and so then if the pump itself was placed in an improper location or in a location that would lead to such an accident, or wouldn't that then be launching an instrument of harm?
Your Honors, the placement, the pump itself was not a dangerous condition.
It's the hose. It's the hose.
It's the hose.
It's the hose.
Of course.
Right. So I don't know how many times you go to the gas station to put air in your tires, but you know that many times when people put air in their tires, they do not put the hose back up on the little thing that you're supposed to put it back on, right?
Right.
Instead, they just let it stay on the ground. And so, again, as my colleague stated, if the pump itself is placed in a position where that hose is now going to extend out onto the sidewalk, which is what the allegation is here, then why would that not constitute launching?
Because, first of all, there was no, it made no sense to put this hose across the sidewalk. the fact that the hose could have reached across the sidewalk didn't mean that anyone ever used it in that capacity. The machine itself and the hose was on the property of the gas station. Anyone using the hose was to pull into the gas station and use the hose. If they didn't put it back on the machine, it would just be on the ground at the base of the machine. It wouldn't have been
The
draped.
sidewalk
On the
section,
side,
right?
But
There's a photograph in the record that shows the hose laying in front of the pump on the sidewalk.
right, but not draped across the sidewalk in front of the neighboring.
Doesn't matter. It's on the sidewalk enough that someone could walk onto it again and snarl and go down.
That's the whole point. That's what the issue is in terms of the placement of the pump itself, whether it's too close perhaps to the end of the gas station and then extending out to the sidewalk.
Your Honor, I think that the issue of the hose itself being there is the dangerous condition, not necessarily the machine that had the hose being necessarily too close to the.
Well, the testimony was it was both the gas station, the owner of the gas station, as well as your client who agreed upon where the
That is correct.
pump was going to be placed.
Yes. It's still our position, however, that it's the hose itself. If it was in fact where it was, that was the dangerous.
Well, there was also testimony, I thought, that the determination as to the placement of the machine was so that it would be visible to motorists, right? So they would know that there was a air pump.
Right, but they still had to pull into the gas station in order to use it. They weren't to drape it across the sidewalk on 11th
This
Avenue.
distinction between the pump and the hose, but the pump doesn't work without the hose, right?
Right, but the pump works at the gas station. It doesn't.
But the hose is an integral part of that pump.
The hose is connected to the pump.
Understood, Your Honors. In the balance of my time, I can discuss, how it's pure speculation that the hose was even involved in the act.
Thank you. Yes.
Please the court, Your Honor. My name is Kevin Martano, representing the gas station, not the owner, the owner of the property. Judge Getz found that it was the placement of the air hose that was the perhaps launching the force or instrument of harm, not where the hose was or anything else like that. And it was the third-party defendant who was responsible for the placement of that. Judge Getz said that is satisfies the first prong of the Espinal case, and it should be a question of fact as to whether or not this launched a force of harm, and that the third-party defendant would perhaps be liable for this. And if I have no other questions, that's the basis of my argument. Thank you.
Thank you.
Your Honors, getting back to the second point that I wanted to make, even if we had a duty, there is no credible evidence whatsoever that the plaintiff here tripped over this hose. He testified that he never saw the hose before or after his accident. A year later, he went back to the location and saw that there was a gas station there that had an air pump nearby that had a hose.
Well, he did testify that he became entangled or tangled in something, which would suggest that he became entangled or tangled in the hose, right?
Well, he felt that he was ensnarled in something, but
Ensnarled or tangled.
at no
in
point
something.
did he ever see this hose, neither before nor after. And he has a
Except
history
it's
of
like
tripping
you
over his
have
own
the
feet.
combination of things, right? He testifies when he felt like it was snarled and entangled. You have the hose that's on the ground, and those two circumstances could lead a juror to find that the hose was what caused him to fall, even though he didn't see the hose before he fell.
I think, Your Honor, that that's pure speculation.
Well, I mean, that's what you're going to argue to the jury, right?
And he also has a history of tripping over his own feet.
Yeah. I mean, cold feet doesn't necessarily. He's playing tennis. I trip when I play tennis.
Well, he said he has peripheral neuropathy, and he did at one point trip over his own feet. Unless you have any other questions. Thank you.
Thank you. Last case for argument, People v. Dwayne Williams.
Good afternoon, and may it please the court. Jane Merrill for Dwayne Williams. Without any proof that Mr. Williams' conviction constituted a felony under New York law, the SORA court erred in applying the override to adjudicate Mr. Williams a level 3 registrant.
In the People v. Hoyas case, this court considered such a question, not in the context of the override, but it said that where someone is required to register in another state, that state at that time was Connecticut, they would be required to register here, notwithstanding that the Connecticut felony is not the equivalent of any New York felony. Can that be now maybe expanded into the basis of an override? Because we've already decided that question. If you're required to register elsewhere under subsection 2, then you're going to be required to register here.
I'm sorry, can the standard for what be imported to the override?
The principle that was laid out in the Hoyas-Sanchez case, can that now be extended into this case?
No, Your Honor, it can't. In this case deals exclusively with the override, which uses the same language as Factor 9, and the courts of this state, and indeed the Court of Appeals, has been very clear that when we're dealing with Factor 9, we're using the North test. That is consistent throughout, and there's just no reason to deviate from that here.
No, but the B2 is different because in B2, there's that extra thing that you're required to register in the state in which, because it's clearly a sex crime. So, and you're required to register. That's different from just deciding whether having 6 pieces of pornography in Connecticut equals a felony here in New York. That's a different determination. What we've said is if you have to register in another state for a sex crime, then you have to register here for the same sex crime. And doesn't that automatically satisfy the override?
Absolutely not. That's
okay. So how come?
So there's no dispute here that Mr. Williams was required to register, but it's been very clear from the case law that registrability and the risk level are different standards. And Justice Wilson put that very well in his dissent in People v. Perez. In that case, he made clear that the features of registrability were a policy decision that came from the legislature, whereas the features of risk assessment, which is what we're dealing with here, were left to what he said was a psychologically based.
Correction Law 168 is about registrability, so it's not informative in terms of whether there was an established conviction.
That's correct, Your Honor.
Or New York conviction, I should say, to be more specific.
That's correct, 168, and indeed the guidelines as a whole don't address the import of a foreign conviction. That's why Perez exists. That's why this court had to deal with this question in Cruz and in many cases since, because 168
What's
leaves
your
that gap.
argument as to why the same standard that's applied for Factor 9 should be applied for an override? Isn't there a reasonable view a reasonable view that the override should be another standard, because now you're looking at something extra aside from the conviction itself and whether it was a New York conviction?
May I?
Yes. Well.
Yes, please.
Thank you, Your Honor. So there is a good reason to treat those the same, and that is because it would lead to disparate results. Because someone convicted of a misdemeanor sex offense in New York, the conduct that is evaluated would be assessed points under Factor 9. If that same conduct occurred somewhere else, now we're saying that that can automatically lead to an override when we're considering it as an out-of-state conviction. This is the same language occurring in the same context and basic principles of statutory interpretation.
Counsel, in terms of the override, could it be that the important focus of the override is not so much the conviction, but that in fact the defendant had to register based on the sex conviction of a sister state?
And it's not just any sex conviction; it's the felony.
Well, what would be a felony in their state, correct?
Right.
Yes, and that's why that's why the D2 registrability standard exists, because we do take that seriously as a state that someone was convicted of a felony and was required to register. But that doesn't inexorably lead to the override. The paramount concern of a SORA adjudication is accuracy. The guidelines weigh a misdemeanor differently from a felony, and they made that determination based on a review of New York case law, or
So
sorry, of
in
New
this
York
case-
statutes.
In this case, could the judge have taken into consideration, what was this, the Nebraska felony conviction in determining, or in rendering a decision to bump it up?
Absolutely, that's a proper.
So your point is only that it's not automatic.
It's not automatic. I do think there's some question about whether it would be proper grounds for an override, given that it would be considered under Factor 9. But certainly that is grounds that judges can and do and should take into consideration for an
Wait a
override.
second. You're saying the fact that somebody is required to, is a registered sex offender in another state wouldn't give a judge reason to bump them up to 3 here?
I am saying that it does
I
not
thought that
automatically.
when you just,
No,
not
you're saying it's not
automatic.
automatic. So if the person was, in this case, Nebraska, say it was a risk level 1 in Nebraska, so that here he would immediately be bumped up to a level 2 because of the Nebraska.
Yes, I think that would be an appropriate use of.
But you're stating that it should not be automatic, and that the judge should make some statement on the record or state that the reason they're doing it is because of X, Y, and Z, because of Nebraska.
Yeah, we don't really even get into the equity concerns of, is this fair, or is this just because we have this test
So
that
is it
governs?
just that, or are you saying that in order for there to be a bump up, that the Nebraska crime has to be a crime in New York?
Not that it has to be a crime in New York, because the Factor 9 accounts really well
for that.
for whether it was a violent felony, a sex crime of any sort. That is fully considered. The automatic override is a different creature, and it kicks in only when it also constitutes a felony in New York.
Right, so you're asking for us to what?
To apply the North test to the override as well. That's it. That's something that this court and the Court of Appeals has
When
done.
applying the North test applying the North test to the override, what did the court have to find in order to grant an override?
In applying the North test, the prosecution would have first had to identify a comparable New York statute, then compare the elements.
So then what would be the point of the B2, which makes it automatic
I'm sorry, I don't follow
in
you.
terms of registrability? Why wouldn't that be enough? Why would you also have to do this second step?
Well, Your Honor, because there's no dispute here that Mr. Williams was registrable. The question is, at what level?
Was registered.
Yeah, at what level?
Not registrable. He was registered.
Well, he was
You're saying we have to go the second step, even though he clearly was registered, and under B2, he would be registered here.
Absolutely. For example, in any out-of-state conviction, Your Honor, where someone is required to register, not because of a new New York offense, but because of an existing, even though they are registered, even if, for example, here, Mr. Williams hadn't been convicted of this forcible touching, but had moved to New York, he would have then been entitled to a SORA hearing to determine his risk level. So we would be in the same position.
Right, so you're just stating there should be some statement on the record as to why, and the people should have the burden of going forward to stating why there should be a bump up based upon that out-of-state conviction.
Yes, because I think it's very.
But aren't you also saying that out-of-state conviction also has to be a felony here in New York?
Only, Your Honor, to apply the automatic override to a level 3. Only for that purpose.
Automatic, but if it's discretionary, you don't have any problem with the judge saying, registered here, I'm taking that into consideration, and in my discretion, bumping up.
I think that's something courts do absolutely every day and will continue to, regardless of the court's ruling on this particular issue. The issue here is really quite narrow for when someone has a prior conviction that they are required to register in another state. Is that alone grounds for automatically making them level 3?
But without something in the record as to why there would be a bump up.
Yes, and just respectfully, that's.
Well, you have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Carter Bergen for the people. Again, just to jump right into the override. So certainly it's not disputed that defendant had this out-of-state conviction and that he was required to register in Nebraska. And that certainly was the basis that the SORA court and the board. So the board, before it even gets to the SORA court, the board reviews, makes a recommendation, does the RAI. They first recommended the override, and then the judge ultimately is the one that has to sign off on it and approve it.
Well, let me ask you, in this case, it appeared to me that the judge felt that it was automatic, that the judge didn't have any discretion to do it. So do you agree with that, or do you think the judge said, in my discretion, I'm going to follow what the board says?
Well, I think it's always the board, it's what the board does before the SORA hearing, it's certainly only a recommendation, and it's the judge's decision.
But again,
So is
think the judge said, I have to do this.
Right, so is there anything in the corrections law or any case law which would state that it is automatic? That because of this out-of-state conviction and registration, that it constitutes an automatic bump up here in New York?
I'm not sure if there's any case law. Well, I think, there's certainly appellate term cases. I know ones we...
I'm sorry, there are appellate term cases. Anything other than appellate term cases?
Nothing to directly address this issue. And I don't think the judge...
Well, why should it be automatic in your view? Because do you follow the analysis that it would... Why should it be automatic? I'll just leave it at that question.
Well, I think, again, the point of a SORA hearing is to assess risk. And when we're looking at those who are most likely to, it's likelihood of reoffense and likelihood of risk that would be caused if a defendant were to reoffend. The ones that are most likely to reoffend in a SORA context are ones that have previous sex offenses that they've already committed.
Right.
And then if those, so I think the likelihood that they would, the harm or the likelihood that they would reoffend is very high. So
But it doesn't have to be automatic in that the judge, in making a determination as to whether to downward depart or upward, would take all of that into consideration and make a determination as to the facts presented, whether there should be an upward modification or downward.
So I think maybe thinking of it this way might help. So I think first the judge and the SORA hearing is focused on what is the scoring and what level, presumptive level, is the defendant's should be. So that I think that's what the judge was doing first here when they were looking at the override.
So the defendant here was presumptive 2, right?
Presumptive 2, and then before we get to actually adjudicating him as a sex offender, the judge says he's presumptive 2 on the points, but that this override does apply because he was required to register out of state. And then, so in a sense, it is automatic in that he's a presumptive level 3, but then there's certainly always the opportunity to argue for a downward departure.
He's a presumptive level 3 based upon the out-of-state registration conviction.
So wait, so your argument is that based on the out-of-state conviction and registration, that the bump up is automatic, and then the court had an opportunity to do a downward departure?
Yes.
What makes it automatic?
I think just the operation of how the override works. It's for anyone who has a prior felony sex offense.
But isn't that accounted for under Factor 9?
Yeah.
Well, yes, it certainly is. It takes that into account. But I think, again, the board created this override for someone who does have specifically a felony sex offense. And I think the reason that they did that is as I noted, that...
No, in this case they did, but you're saying that there's board, the sort of regs to the RAI in which the board says we think this is automatic?
Yes. When they created the override, they said any defendant who has previously been convicted of a felony sex offense is automatically, presumptively a level 3. That's from the guidelines.
Okay. I'm going to give you a fact pattern then. Let's assume that the crime that he was convicted of in Nebraska, that you're saying will now subject him to an automatic override, let's assume it's not a crime in New York at all. Do we then have an automatic override?
Well, I think it's our position that it would have to be a felony in the out-of-state, in the out-of-state, in the foreign jurisdiction.
I'm asking you, if in New York the conduct is no crime.
Or the conduct is a
elements.
misdemeanor. How about it's a misdemeanor? A misdemeanor would work. So it's a felony in Nebraska, but it's a misdemeanor here in New York.
I still think the override would be proper because, again,
You think it would be proper, but not that it would be proper, would it be pursuant to the regs, to the statute?
So is it your position that because it's a registerable offense and a felony, in Nebraska, which, requires him to register here under subsection 2, B2, I think it is, that gives the basis for the automatic override? Because
Yes.
how else do you reach that if that's not that is your argument?
That is the basis. So the basis for the override is the fact that he had committed this out-of-state felony sex offense, and then that required him to register in the out-of-state jurisdiction. That is
And
our
you're
position.
saying the
And that's what
board
the judge
doesn't
relied.
have any authority to not put that override in?
I'm sorry, you said the judge? I'm sorry?
I'm talking about the board.
The board.
The board doesn't have any authority to not recommend an override in that situation?
I'm not certain. I mean, certainly, I guess the board can do what they would like, but I think when they
That's what I'm trying to figure out. Is it just like a matter of must be done, or is that what the board's policy position is? They did it in this case, and the court followed it, or is it the board itself, based on its own regs, has no authority to say, nah, this is not a case where we're going to apply the override?
honestly, Your Honor, I'm certainly not. I'm not sure what discretion the board has, but I know. So again, the board makes the recommendation, but the people certainly do still have to make prove the facts at the SORA hearing, and the judge does still have.
Right, because I think we should not use the term automatic. I think it should be presumptive, right?
Well,
I don't think we should say an automatic bump up. I think it should be a presumptive bump up, because I think that the court would still have to make a determination that they're not going to follow it. And for what, based upon arguments by counsel, et cetera, and say, okay, it's presumptive level 3 because of this felony registered conviction in Nebraska, but for whatever reason, I'm going to keep it at a level 2.
Well, I think that's fair. I think if you want to keep it as it's presumptive, I think our main argument is not whether or not it's automatic or presumptive. It's just the simple fact that we can use the prior felony offense and the fact that he had to register to get to level 3.
Okay.
I think that's our main argument. It's not whether presumptive or automatic. It's just that it was proper that the judge used that and didn't look at the elements of the Nebraska offense.
That's without looking at comparing the elements of Nebraska to New York.
Right.
Correct. It's argument that that was okay. Again, not the automatic or presumptive element of it.
Thank you.
Thank you.
Your Honors, at the heart of this case is what a felony means in the context of an override, not in the context of registrability. That, Your Honor, is what was settled in Hoyos-Sanchez, but in the context of an override. And an override, like Factor 9, is a creature of the regs, as Your Honor said. There's no reason to treat that definition of a felony as different from the definition of a felony in an override. As Your Honor said, here it was entirely possible that Mr. Williams' conduct constituted no more than a misdemeanor. We don't know that because we haven't performed the test to check.
There should be some type of inquiry, and
That's all.
It should not be presumptive. It should be some type of inquiry into exactly what that Nebraska conviction for first-degree sexual assault was.
Yes, and the nature of...
May I interrupt? You're not just saying that. You're saying, and it has to be a felony here in New York. That's a different thing. If it's that's part B of what you're saying. Not only does it have to be a serious crime in the state in where it was occurred, but then the judge has to find the same thing here.
Your Honor,
Which doesn't give comedy, I guess, to other states' definitions of a felony.
yes, because that is precisely what all of the courts of New York have done in the context of evaluating this question, is we have some test, and the nature of that test is to determine equivalence. That's what was done in North. That's what was done in Perez. That's what was done in
We haven't ever done it in this context before.
Not quite, Your Honor.
And the board's own regs.
Well, the appellate term has held that it is.
The appellate term has addressed this question. This court has addressed this question, albeit not quite as directly as it's presented here, in both Bean and Richardson, in which it certainly implied, if not explicitly held, that this is the correct test. This is not breaking new ground. This is continuing to uphold the applicability of the North test in the context of board-created statutes as distinct from registrability.
Thank you.
Thank you.
both.